in which individuals have already been accused. Bonds have been set. And today we're going to get a status of the cases. If you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. If you are unable, you have a right to an attorney. If you're unable to afford one, an attorney will be appointed to represent you from either the public defender's office or from our conflict defense list. Now, we're going to be addressing a lot of cases at the Fulton County Jail or various locations of the jail. I do see that there are people joining us on Zoom. Please remember that although we are addressing this calendar virtually, if you are attending this Zoom proceedings, you are expected to behave like you are in an actual courtroom. So you're not supposed to be walking around. Oops, Casey. You're not supposed to be walking around. You're supposed to be dressed appropriately. No eating, drinking, smoking. So on that note, let's begin with Courtroom 2, I think.
Hold on a second. Good morning, Judge Law. We're going to start with, on the probation calendar, it's going to be positions 5 and 6. Mr. Holton.
And Your Honor, after that, can we do position 11 and 12, Crystal Upshaw?
Oh, Ms. Milton, let us do a couple because we got a lot here in Courtroom 2 today.
All right, Deputy Milton, hang tight. As soon as Deputy Francois gives me the green light, we'll be at ACDC. Just hang tight. I'll be right there. All right.
Thank you, Your Honor.
Francois, can you tell me the positions again that you want me to begin with? 5 and 6 on what calendar?
5 and 6 probation calendar.
How many hours would you?
Mr. Holton.
Well, we're partway there.
You see the probation calendar? Okay, Officer Allison, good morning.
Good morning.
For purposes of this calendar, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. We are in Courtroom 2. Just give me a moment to pull up those cases. This is, are you Mr. Daniel Holton?
Yes, Your Honor, he is.
Okay, thank you, Mr. McLean. This is Daniel Patrick Holton, and the underlying case is 20 CR 3040A, in which there were convictions for one or more of these charges: DUI, driving under the influence of drugs, illegal stopping or parking, failure to maintain lane, and reckless driving. You've got a probation violation matter with regards to this, with regards to today, and your probation case is 23 PV 1710. So, Mr. Holton, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. Officer Allison, why are we seeking a revocation in this case?
Yes, Mr. Holton, he owes court fines and surcharges in a total of $1,497.50, probation supervision fees in a total of $400, victim crime funds in a total of $90, failed to report as directed on March 6, 2023, March 13, 2023, and March 27, 2023, and he failed to complete 260 hours of community service. Mr. Holton has 527 days remaining. Probation is recommended to continue on probation and to start the community service within 30 days.
Was he required to do ADT or risk reduction or victim impact panel or anything to that effect?
I can check, but I don't think so. I'll check for you.
All right. Mr. McLean, any objection to continuing on probation?
No, Your Honor, he does tell me he's already done 90 hours, and that's a good start on the 240. But of course, it doesn't get him the completion letter yet.
Okay. Go ahead, Ms. Officer Ellison.
So he wasn't ordered to do the ADET or anything else. He was just ordered to the community service. He was ordered to do 390 in total. He just handed in 129 hours. So we were still missing the 260.
Okay, thank you.
It sounds like,
Um,
it's probably
Miss-
it sounds like some fines were converted into hours.
No, he was just court ordered to do those hours.
And how did he accrue over $1,497? Are those the fines?
Yes, that is the fine and the 1,497.
Okay. Anything else, Mr. McLean?
Nothing, Your Honor.
All right, we're going to continue Mr. Holton on probation. And has he got any other holds at the jail?
He does not believe so, Your Honor.
All right, he'll report to probation next Thursday, which is December 28th. Am I correct or am I going up? December 28th before 3 p.m. Officer Allison, given the holidays, it'll be difficult to do it within 48 hours unless you want him to come in on. So that's why it's
No,
next
that's
Thursday.
fine.
Okay. So
And
it's
Your
going to be December 28th before 3 p.m. at 132 Mitchell Street.
Now,
He will
Your-
report to probation twice a month for the next 6 months of the remainder of his 527 days. And reporting twice a month, he will also be required to start his continue with his community service, and he needs to complete the 260 hours of work that is required to do. He also needs to pay off his fines. The first $500 of his fines must be paid off within the next 4 months, within the next 120 days. He's had adequate time to put off the fine, so this is required. After that, after the 6 months, his probation will be amended to once a month. He will report once a month for the remainder of the 520, for the remainder of what's left of the 527 days. Any questions, Mr. McLean?
Your Honor, he does think that perhaps he has a Cherokee hold, so we'll see if that works.
Okay. If he has a hold, then he must report to Fulton County Probation by the next business day after he's released from any holds. But if he doesn't show up, well, you know the red carpet rolls out again for him.
Exactly.
All right. Thank you, Mr. McLean.
Thank you.
You're done.
Oh, thank you.
Number 17, Mr. Dorsey.
Is that on SAP?
Yes, it's on a regular calendar.
$17. That's this is State versus Ronald Dorsey. Mr. Dorsey is accused of loitering and prowling on December 8th, 2023 in case 23 CR 7823A. Mr. Dorsey, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Let me see, Mr. Pierre Thomas, is this case getting transferred or is it still in limbo?
Your Honor, it's still in the process of being transferred.
Okay, and Mr. McLean, do you waive a reading of the accusation?
We do, Your Honor. We've gone over it. Mr. Dorsey pleads not guilty.
Mr. Dorsey, you've been accused of the loitering and prowling charge, which is a misdemeanor. Upon your entry of a not guilty plea, the case will be scheduled for trial. Or it may be transferred to the district attorney's office and superior court if they decide to accept this matter as a felony. But in the meantime, if it does go to a trial in misdemeanor court, then the prosecution would have the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state does prevail, you could be convicted of this offense and face a penalty of up to a year in prison and or up to a $1,000 fine. Given this information, how do you plead? Mr. Dorsey, given this information, how do you plead?
Not guilty.
Not guilty. Okay, I'll accept your not guilty plea. Case is further notice for trial. Thank you.
Number 33, Wilson on the regular calendar.
All right, this is State versus Edward James Wilson, 23 CR 7819E, accused of battery from December 9th, 2023. Mr. Wilson, you've been advised of your right to remain silent, and your attorney is Mr. Finley, who has been MIA for a while, but welcome back, Mr. Finley.
Good to see you, Judge Law. Hope
You
you've been
too. All right, and this is going to be a negotiated plea, Mr. Finley?
Sorry, Judge, I couldn't hear you, but this is going to be a plea.
Okay. Mr. Wilson, in order to proceed with the plea hearing, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you, sir. Ms. Pope, what is the recommendation for Mr. Wilson?
And Judge,
Recommendation.
Judge, I apologize. I should have said it's non-negotiated, just jail time at issue, Your Honor.
Oh, that it is non-negotiated. Okay.
Yep.
All right. Ms. Pope, is there additional jail time involved?
Yes, yes, Your Honor, there is. The recommendation is 12 months served, 60 days credit for 13 days from 12/9/2023, balance probated, 12-week
Thank you, Bogo.
anger management, 40 hours community service, no further contact with Marcellus Wisely or Wisely Marcellus, stay away from 1346 Easton Street, Northwest Atlanta, Georgia.
All right.
Okay, keep your mask on.
Mr. Wilson, this is a non-negotiated plea. The prosecution has just indicated their recommendation, which involves the recommendation that you serve additional jail time and do 12 weeks of anger management classes and 40 hours of community service. Let's see what your attorney would be recommending, and then I will let you know what my decision is. If you're not happy with my decision, you of course have the right to plead not guilty and have the case scheduled for trial. Mr. Finling, what's what's the recommendation for your client?
Yes, Judge. Mr. Wilson is 41 years old, Judge. He has been working full-time. He works at the Hilton Hotel. He does have 2 kids, ages 12 and 8, of which he spends a lot of time with and helps financially support, Your Honor. Mr. Wilson has no problem with the community service, with the stay away, with the no further contact, with the anger management. Just jail time is an issue. As the state said, they're asking for him to do 17 more days. I'm asking for it to be 30 days to serve, which after the 2-for-1 would give him 2 additional days. So he would still have to serve a few more days. But I'm asking, yes, Your Honor, for him to serve only 2 more days instead of 17 more days, Judge.
All right. My pretrial officer is Ms. Tyson. Good morning. Ms. Tyson, do you have good morning. Do you have a GCIC on Edward Wilson, position 33 on the SAP calendar?
I do. One moment. Mr. Wilson, looks like he has 3 arrest cycles out of Georgia beginning in 2021. He does have a felony case out of Gwinnett County for aggravated assault. He took a plea on that case October 28th of 2022, received first offender treatment on that case. He has probation for 5 years on that case, so he is on probation. He has 1 FTA from 2022 out of Gwinnett County, and he does have a hold out of Gwinnett County. It looks like for a probation violation.
Mhm.
He has 1 cycle out of Florida from 2002. That case was dismissed. Looks like it was for hindering, assaulting, or interfering with firefighter duty. Case was dismissed. He has 1 cycle out of Louisiana from 2017 for theft of goods. No dispositions listed on the GCIC for that case. He has 9 cycles out of Colorado beginning in 2010. His last arrest was in 2016, and that was for trespassing, premise or structure, and he did take a misdemeanor plea on that case.
Oh, that's good. Thank you.
Mhm.
I remember this case. I think I set the bond on this one. Mr. Finling, I'm going to accept the state's recommendation This is an allegation of violence while Mr. Wilson was on probation for a violent conviction. And given his history, I do believe that the state's recommendation is reasonable. Would your client like to continue with the plea? He would be required to complete another, well, let me see now. So be 16.
He's 17, Judge.
17 more days at jail, and then he'll be on probation in addition to his felony probation.
He has told me he does want to move forward, Judge.
I beg your pardon?
He just told me he does want to move forward, Judge. So we-
Okay. Mr. Wilson, and Mr. Finling, do you stipulate to the factual basis, venue, and ID?
Do so stipulate.
Mr. Wilson, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood everything that's been going on so far in your case?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
Is anyone forcing you to accept this to enter this guilty plea today?
No, Your Honor.
And are you entering this plea freely, willingly, and knowingly?
Yes, Your Honor.
And are you entering this plea because you know you're guilty of this offense?
Yes, Your Honor.
I'm sorry, are you entering this guilty plea because you know you're guilty of this offense?
Yes, Your Honor.
All right. And has it been explained to you that if you decide to enter this plea, that you would have to give up your right to a trial? You will not get a chance to go back to court and have a trial in front of a judge or a jury, to confront your accuser, to be able to challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I have. Yes, Your Honor.
How do you plead to one count of battery from December 9th, 2023?
Guilty.
Your sentence is 12 months to serve 60 days, credit for time served 13 days. After you've completed this time, and if you have no other holds, you have to report to probation at the first available business day, which will be Monday, Tuesday, or Thursday. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete a 12-week anger management program and complete 40 hours of community service at any nonprofit agency that's not a church and not a school. You are to stay 200 yards away from Marcellus Wisley, and you cannot return to 1346 Eason Street in Northwest Atlanta, Georgia. However, I will let you go back there one time only with a police officer to retrieve your personal belongings, if you have any there. Understood?
Yes, Your Honor.
That concludes the case. Thank you.
Thank you. Thank you.
Number 24, Harvey.
And Judge, this is a gentleman I'm gonna need to talk to. There was no offer given. It said recommended for felony transfer, and there was no offer. So if there is an offer, I haven't been able to relay it.
All right.
Your Honor, that's correct. I'm sorry.
Go ahead. Go ahead.
This defendant does have a prior battery family violence conviction, so this case was transferred to the DA's office, or is in the process of being transferred to the DA's office.
Have you all submitted the transfer order?
It has been submitted.
We have not submitted the transfer
Oh.
order. We have submitted the recommendation that it be transferred.
okay.
And the basis for the transfer is recidivist. So it's not
Okay.
a transfer that the DA's office can decline.
All right. Mr. Finling, if your client wants, if I can arraign this case pending the transfer, and then at least it'll either go to trial in state court or it'll be transferred to Superior Court.
Yeah, if we could just go ahead and arraign it, Judge, please.
All right. And do you waive a reading of the accusation?
Yes, Your Honor.
Okay. Mr. Kevin Harvey, your case is 23 CR 7801G. Presently, you are accused of a misdemeanor offense of battery family violence from December 7th, 2023. You have been advised of your right to remain silent, and your attorney is Mr. Finling. As you have already observed, the prosecutor in state court is recommending that this case be sent to Superior Court to be tried as a felony matter based on an alleged prior conviction of battery family violence. So presently, we are going to arraign your case, that is, to accept your not guilty plea. And upon your entry of such a plea, your case will be scheduled for trial, or it may be transferred to Superior Court to be tried as a felony matter. If it remains with the State Court of Fulton County and the case is scheduled for trial, then the prosecutor would have the complete burden to prove this misdemeanor charge against you beyond a reasonable doubt. If you are convicted of this misdemeanor offense, then you could face a penalty of up to a year in prison and/or up to $1,000 fine. If such a conviction does occur, then this case would never be transferred to Superior Court as a felony matter. Given this information, how do you plead?
I guess.
Your case is going to be further notice for trial in state court and/or transferred to Superior Court as a felony matter. Thank you.
Thank you.
Judge Law, if we could address possibly Nigel Folks, Mr. Patterson and I are here to address that case.
Deputy Francois, is Nigel Folks in your courtroom?
Is
In
Mr.
court.
Falk in here? Falk?
No, that's you, okay, that's Jackie Patterson's.
I'm checking my full sheet to see what floor he's on. Give me 1 second, Judge.
All right. In the meantime, which case shall I take up next in courtroom 2, or shall I go to ACDC?
There is a revocation, Mr. Hill, we could do very quickly.
Okay, we can do real quick,
Hill.
no.
All right, Mr. Patterson and Ms. Falk, as soon as Deputy Francois gives me information on where he's located and an ETA, that would help matters, but.
I'm gonna do my Cobb County guy and then we can go to ACDC.
Okay, but can you
Thank you,
look
Your
into
Honor.
Folks also and have him brought over? Or
He's
tell us where he's gonna chime in from?
He's right here, Your Honor.
Where? Where's Nigel Folks?
Okay,
He's in ACDC, Your Honor.
All right, that worked out better. Courtroom 2, please hold. I'll be right with you.
thank you.
ACDC, are you Mr. Nigel Folks? The gentleman at ACDC, are you Nigel Folks?
Yes, ma'am.
Okay, Mr. Folks, you have a right to remain silent about your case. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your attorney is Mr. Jackie Patterson. Do you see him on the screen? He's
Yes.
wearing a white shirt.
Yes, Your Honor.
All right. Mr. Folks is position 19, 20, 21. And position 19 is 19 CR 5796G, in which he is accused of simple battery against a person who is 65 years or older or who is pregnant at the time of the offense. Position 20, Mr. Folks' case is 22 CR 129G. He's accused of battery, family violence, and 2 counts of cruelty in the 3rd degree from January 10th, 2022. And position 21, Mr. Folks' case is 22 CR 5846G, in which he's accused of simple battery from March 15, 2023. So in Fulton County, he's got offenses from 2019, 2022, and 2023. And Mr. Patterson, is this going to be a plea hearing?
Yes, it's a negotiated plea, Your Honor.
All right. Mr. Folks, if you please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Falk, what is the recommended global offer?
Yes, Your Honor. On position number 19, state's recommendation is 12 months to serve, credit for time served 60 days. That's going to be from July 9th to July 20th of 2019 and November 4th of 2023. Position 20, which is the 22 CR 129G case. On count 1, the family violence battery, 12 months to serve to run consecutive with case the previous 19 CR case. We are also requesting credit for time served for 52 days. That's from January 10th, 2022 to January 13th of 2022, and then November 4th of 2023 to today. Count 2, the cruelty to children, would be 12 months consecutive to count 1, FVIP, no further contact. And then cruelty to children, count 3 is 12 months probation consecutive to count 2. On the last case, 21.
It doesn't appear that the
Just
public
one
defenders
second.
are here just yet.
Mr. Patterson, if you could mute your screen, please.
Come back on probably
Thank you. No, you need your video on. We were just hearing background noise. Oops. Well, I'm sure there we go. Perfect. Thank you.
I'm back, Judge.
And
I just wanted it muted because we could hear background noise in your office. Okay. Sorry about that, Ms. Polk. Please continue.
yes, position 21, which is the 5846G case, 12 months to serve, credit for time served, 48 days. That's from November 3rd of 2023, and that's to run consecutive. So the total sentence on all of these cases is 60 months to serve 36 months. Balance on probation, family violence intervention program, no further contact with Ms. Kamisha Ragland. I will say that Ms. Ragland is here on the line. She does disagree with the jail time on this case, but is agreeable to the family violence intervention program. And I will sound for her at this time so she may speak. I will ask that the defense stipulate to venue, factual basis, and identification for the purposes of this plea.
So stipulated.
All right. Kamisha, what did you say her name was? Ms. Ragland?
Yes, Your Honor.
There she is. All right. Ms. Ragland, good morning. My name is Judge Law. Did you want to add to these proceedings?
Yes, I just wanted to say that basically I was asking the state to kind of not give a lesser sentence, but a more respectable sentence to his children, just off the fact that we have 3 kids that need him, and this would be an extenuate time away from his children. And I just don't believe in separating families, especially with something like this. He needs rehab. Jail is not rehab for him. I feel like jail would just make matters worse. I feel like he needs a medical intervention, and jail wouldn't necessarily provide that in this circumstance.
And has he sought treatment in the past?
He has not sought treatment. He has been trying, but of course,
what? Complete the sentence, but what?
I'm really not sure. I just try to support him in any way I can, especially with the mental health issues that he's been facing. I face mental.
But what has he done in the past to address that? Because right now, I've got 3 open cases, including battery. You are the alleged victim in these cases, and the cases also involve violence in front of children. So if you're telling me, but what, I need to know the rest of the sentence. What has he done in the past?
He doesn't have medical assistance. He doesn't have the necessary resources to seek the help that he needs.
All right.
And so if he's able to get that,
Understood, Ms. Ragland. Thank you. Mr. Patterson, anything else to add in addition to the stipulations?
No, Your Honor, my client understands that although his sentence is 36 months, I informed him that if the sheriff wanted to release him for a day, that the sheriff could, but I told him it is not guaranteed because his sentence is 36 months.
Mr. Nigel Folks, you've already been sworn. First of all, have you consumed any medicine or alcohol?
No, ma'am.
And have you been in conversations with your attorney about the sentence recommendations in all your 3 cases?
Yes, Your Honor.
And did you understand the sentence recommendations and the arguments presented by the prosecutor with regards to why they're seeking such an extended time period in jail?
Yes, Your Honor.
And Are you satisfied with your legal representation?
Yes, Your Honor.
Is anyone forcing you or inducing you to plead guilty to these three cases today?
No, Your Honor.
Have you gone over the plea paperwork with your attorney with regards to what you are pleading guilty to, what programs you have to do, how long you'll be in jail, and so forth?
Yes, Your Honor.
And do you accept these terms freely, willingly, and voluntarily?
Yes.
I'm sorry, do you accept these terms freely, willingly, and voluntarily?
Yes, ma'am. Yes, Your Honor.
Are you pleading guilty to these three cases today because you are in fact guilty of these offenses?
Yes, ma'am. Yes, Your Honor.
All right. So if you decide to plead guilty, you understand that you will not have a trial. You will not go back to court and face a judge or a jury. You will not get a chance to sit down with your attorney in a courtroom to challenge the witnesses who will testify against you, to confront your accuser, to be able to challenge the evidence brought against you, to have your attorney cross-examine witnesses and question the evidence brought against you, to have and for the opportunity to have the state try to prove the charges against you in all these three cases beyond a reasonable doubt. Are you prepared to give up all these rights?
Yes, Your Honor.
And you understand that if I sentence you today according to what the prosecutor is seeking, that will be the final decision in these three cases, and that you do not have a right to appeal.
Yes, Your Honor.
Are you still willing to move forward with these pleas?
Yes, ma'am.
One of the charges to which you're pleading guilty is battery, family violence. If you decide to plead guilty to that, that conviction will go on your record. Do you understand that?
Yes, ma'am.
And do you understand that if you ever get arrested again for battery, family violence, it will automatically be a felony charge?
Yes, ma'am.
Your Honor, we're asking that all of these be consolidated for the purposes of this plea, and that since he has no previous felony convictions and have never used first offenders, we're asking the court to consolidate. That way, this will be considered a one incident versus three.
Your Honor, state objects to that. We have never had that discussion. This is the first time
I
this has come up.
I was just asking. I never
No,
said we had.
I understand, but that's my understanding is also that is something the state normally does by joinder, which we have not done.
Well, Your Honor, we're moving forward, not a problem.
I'm not going to do this under first offender since it was not one of the terms agreed upon by the parties. So I just want Mr. Folks to understand the ramifications of entering this plea. All right, Mr. Folks, in 2019, you were accused of simple battery against a person who is 65 years or older or who is pregnant. How do you plead to this charge?
Yes.
In 2022, you were arrested and accused of battery, family violence, and 2 counts of cruelty in the 3rd degree. How do you plead to these 3 charges?
Yes.
And in 2020, in March 15, 2020, you were accused of simple battery. How do you plead to this particular charge?
Guilty.
For the 2019 offense on simple battery is 12 months to serve, credit for time served 60 days. For the 2022 charges, the battery is 12 months to serve consecutive to the 2019 case, credit for time served 52 days. The 1 count of cruelty to children is 12 months consecutive to count 1, and you're required to do a domestic violence intervention program. And the cruelty to children count 3 is 12 months consecutive to count 2. And simple battery from the 2020 matter is 12 months to serve, credit 48 days to run consecutive to positions 19 and 20. In total, Mr. Folks, you'll be, your sentence is 60 months to serve 36 months. Balance of that time will be on probation. Once you are done with your jail time, you'll be on probation, in which you would have to complete a domestic violence intervention program. At all times, you are to have no contact with Kermisha Ragland. You are to stay 200 yards away from her, not contact her in any way, form, or manner. Ms. Ragland, that is the recommendation of the state, and I would accept that recommendation. If you initiate any contact with Mr. Folks, please understand that this could be detrimental to his sentence and detrimental to his probation. Now, with regards to time with the children, he is free to, once he is placed on probation, he is free to file a legitimation action with the appropriate superior court and get a court order with regards to visitation or joint custody with the children that he shares with Ms. Ragland. He is not to consume any illegal drugs, not to consume any alcohol, and he definitely cannot possess any firearms or any kind of weapons. That concludes the plea. Thank you.
Thank you, Judge.
Thank you, Mr. Babson. All right.
Thank you, Your Honor. That concludes my business. May I be excused?
Yes, Ms. Foltz, thank you.
Your Honor.
Position number 10 and 11, Mr. Butt, jail outcome.
Who do we have? Did you say 10 and 11?
I did.
Everybody know that I'm a case manager for today, but can you please see all paperwork to me, not Ms. Willis?
Ladies and gentlemen, attorneys, if you have any documents that need to be submitted to the clerk of court, please make sure you email them to Ms. Casey Strong. Her email is on the chat feature. All right. Do not send it to anyone else but Ms. Casey Strong. Otherwise, it will take longer for your documents to be filed and made effective. All right. Are you Mr. Shemuel Butts?
Yes, ma'am.
Okay. Mr. Butts, you have two cases before us, 20 CR 1790F, that's position 11, in which you are charged with battery, family violence, simple battery, family violence, and 3 counts of criminal trespass from November 14th, 2018. Then you've got another case from July 24th, 2018, and that's 19 CR 6743F, in which you have been accused of obstruction of an officer and simple battery against a police officer or detention officer. With respect to both cases, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. McLean. Okay. Mr. McLean, can you explain to me what we're doing in both these cases? I just want to be sure that I'm reading it correctly. You want a plea in one case and arraign the other one? Mr. McLean, if you could unmute, please.
Yes, Your Honor. Factually, even though they're back in the same year, I think the cases factually are a bit more severable than many of the pairs that we see. He's pleading guilty in case ending in 43F, and he's pleading not guilty, bond is moot in case ending in 90F.
Do you waive a reading on the of the 5 charges in position 11?
We do, Your Honor. We have a copy and we've gone over it.
All right. Mr. Butts, first of all, I'm going to arraign you on the case in which the incidents occurred in November 14th, 2018, under case 20 CR 1790F, in which the 5 misdemeanor charges brought against you are battery, family violence, simple battery, family violence, and 3 counts of criminal trespass, which allegedly occurred at 259 Richardson Street in Atlanta, Georgia, Fulton County, involving an alleged victim by the name of Denitra Dawson. So do you understand? I'm first going to address that case. Do you follow me? All right. Your attorney has waived a reading of the accusation. So with regards to these 5 charges, upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecution has the complete burden to prove all 5 charges against you beyond a reasonable doubt. If the prosecution does prevail and overcomes your legal presumption of innocence, you could be convicted of one or more of these offenses brought against you. Based on the convictions, you can then be sentenced to up to a year in prison and or up to $1,000 fine for each convicted offense. So you could be looking at up to 5 years in jail and or up to a $5,000 fine for this particular case. Given this information, how do you plead?
Not guilty.
Repeat.
Not guilty.
All right. This case has been arraigned and is going to be further noticed for trial. Let's proceed to position number 10, in which Mr. Butts is accused of obstruction of an officer and simple battery against an officer. And this is from July 24th, 2018. Mr. Butts, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Mr. Pierre Thomas, what's the recommendation?
Your Honor, the recommendation from the state is on count 1. Count 1 is to merge with count 2. Count 1 being obstruction of a law enforcement officer. And as it relates to count 2, simple battery against a police officer or a detention officer, the defendant is to serve 68 days in custody, credit for the 34 days that he's already served. Looks like he would have served those days on 7/24/2023 to 7/27/2023, and again, began serving on November 22nd, 2023. Nothing further from the state, Your Honor.
All right. Is balance suspended after that?
I believe it's a time served offer.
Okay.
Yeah.
So it's
Yeah,
served
we-
68, credit for time served 34, balance suspended. So that means it's just time served.
There's no balance, Your Honor.
There's no balance, Your Honor. It's just
Oh.
time served.
You know why? I always just assume it's 12 months to serve. So I beg your pardon. Sorry.
You're fine.
Okay. So, Mr. McLean, now that I've been corrected, do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Butts, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes,
And are you satisfied with your attorney?
yes, ma'am.
Is anyone forcing you to enter a guilty plea to this case?
Ma'am.
And has it been explained to you that with respect to this particular case, that you will not be getting a trial in front of a judge or a jury, that you won't be able to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges in this case beyond a reasonable doubt? Are you prepared to give up these rights?
Ma'am.
Repeat.
Ma'am.
Are you prepared to give up your rights?
Yes, Your Honor.
Okay. How do you plead to one count of simple battery against an officer or a detention officer?
Guilty.
Your sentence is to serve 68 days, credit for time served 34 days. That completes your sentence for this case, and your obligations are concluded. Thank you.
Your Honor, if we can get a stipulation to venue, factual bases, and ID.
We did.
Oh, I thought I did.
We did.
We
Okay,
did.
sorry.
Yeah. Okay, Deputy Francois, are we ready in courtroom 2?
Yes, we are. Thank you, Judge. On the probation calendar, number 13 and 14.
Probation revocation. 13 and 14. Is this Damian Williams with you, Mr. Findlay?
Yes, it is, Judge.
All right. Mr. Damian Williams had a underlying case 21 CR 0000934E, stemming from a driving incident of February 26, 2021, in which he was convicted of one or more of these offenses: DUI, driving under the influence of alcohol less safe, possession of an open alcohol container, and reckless driving. The probation violation matter is addressed as 23 PV 1719. Mr. Williams, you've been advised of your right to remain silent, and your attorney is Mr. Finley. Officer Allison, you already been deemed under oath. What's the basis for the revocation?
Mr. Williams failed to submit a drug and alcohol evaluation, provide proper samples of court-ordered drug and alcohol testing, failed to appear to a prior revocation hearing on November 15, 2023. He did not complete a risk reduction course and did not complete the 100 hours of community service. He has 100 days remaining on his case. The officer over this case would like to make on the record that this defendant is very argumentative. He does not provide drug screens on time. It's always done after the date that it is scheduled to be due. Probation is recommending to revoke the balance.
Well, that's a new one, Mr. Finley. I normally don't get a third party to chime in, but
Judge, as you know, Judge, I did SAP for a long time. I've done probation revocation hearings for a long time, and I'm going to announce this is the most upsetting one I've ever dealt with, because as you'll see in your email, he has completed all the drug tests. He has completed community service. He has completed the risk reduction course. He had numerous text messages to the probation officer where she is literally not responding to him. He's asking, did you receive my community service? Did you receive this? She did not answer. He has a 3-week-old infant, okay? He has twin daughters, that's birthday or Friday, okay? But he is now in jail right before Christmas because the probation officer, and I know they try their best, but unfortunately, just like these gentlemen make mistakes, there was a big boo-boo over the probation office, and they did not, my meeting with him was one of the most upsetting ones I've ever had. So
did you say something by an email? An email
yes,
to whom?
I didn't have Miss Allison. I sent it to just a moment ago, Judge Law, Miss Allen, Miss Strong, Miss Thomas.
To Casey Strong?
So yes, I sent it. She should have it as of about 30 minutes ago. One of the drug tests that she's referring to was on 9/19, September 19th. My client right here texted, said he does not have the funds. He's getting paid the next day. He got paid, took a drug test on 9/21. 2 days later, it came back clean. He got tested again October, it came back clean. I've sent the email where he clearly states there's a letter right here. Community service completion from Victory Christian Center. To whom it may concern, this letter is to verify that Damian Williams completed his 100 hours of community service. Additionally, Judge, he lost his full-time job. Additionally, there was a fine for $924. This is a man that struggles to muster together $924. And you know what he did? He paid the $924. Okay, I've never seen this. And the fact that he's been sitting in an 8-by-8-foot cell and he did everything he was supposed to do is honestly beyond me. And I'm just really glad that I came in contact with him and I can help him, because this is a big mistake and it's really upsetting, honestly.
All right.
So with drug screen policies, if they're not due the day that it is assigned, it is an automatic fail test. So drug screens are to be random. So I understand he texted saying that he don't get paid till a few days later, but at the same point, it's not random. He's doing it on a day that he get paid. But if we schedule it to be on the 19th, it has to be done on the 19th. That's just by policy.
I do understand, Ms. Allison. And unfortunately, one thing that we see too much, and I've had lots of clients not be honest, right? When they say they've completed things and they really haven't. This is not that case, okay? So I understand he completed it a day later, but it came back clean. He paid a $1,000 fine to someone that doesn't have $1,000, okay? He has a 3-week kid that could have gone towards, but he paid that, okay? He is a stand-up guy, one of the more impressive people I've ever dealt with, and I'm being 100% sincere and honest when I say that. And it's extremely upsetting, and I don't think the goal of the criminal justice system is to affect a guy like this who has twins that are 3 years old and an infant right before Christmas, when he did the community service, paid $1,000 fine, of which he doesn't really have the money to, and has completed all the drug tests. Needless to say, he needs to be a release judge as soon as possible so he can be with his family. He can be with his 3-week-old infant baby who's being taken care of by his fiance, who all of his kids are with. Okay, he has 3 kids with his fiance. She's crying to me on the phone last night that she's taking care of the babies by herself. I can hear it sounded like he was crying from 3 different babies going on in the background, and he did everything he was supposed to do.
Ms. Officer Allison, do you have
Yes.
the document with regards to the community service? Apparently it's from a pastor.
It's from, okay, so I do not have documentation of that, but we don't accept community service to be done at a church or a school.
Okay, I'm looking at it and I'm a little perplexed by why this information wasn't conveyed to probation. It has a document signed by the maintenance manager on December 18th, 2023. So this document was obtained 2 days ago. Would that be correct, Mr. Finley?
Sorry, Judge, say that. Sorry, say that one more time, Judge.
We have the document indicating that Mr. Williams has completed his community service, 100 hours community service. And then in there it says he did it in the months of April, May, and June. And it's signed off by a Mike Joyner on December 18th, 2023. So I understand if Mr. Williams has done the community service, I'm just confused why we're getting the letter, well, today, about 3 days ago.
Judge, so I can't speak to that, but I can speak to that, right? He has 100 days left on his probation and he's completed everything.
So I understand why you're upset, and I can understand why Mr. Williams is upset also. But there are certain criteria as to how you complete your conditions on probation. So I'm not going to place blame on anyone, but I'm satisfied that he's at least completed 100 hours of community service. Albeit, we get the information several months after he's done it. Okay, so let's put a pin on that and let's make sure. Now, the random screenings, like you say, he's doing his job, but as you said, if there are financial issues, he's not able to do it on time or in a timely fashion. Probation has a job to make sure that it's done. That's why it's called random screening for folks who are convicted of a DUI. So I can understand why he's upset, but I also understand why probation has to enforce these rules. But given the circumstances right now, I don't have any evidence that he's completed the risk reduction program or the alcohol and drug evaluation. So would you say those are the things that still need to be done?
No, so he has completed the risk reduction course. I'm emailing back and forth with his wife. I do also have another class that he completed. It's not clear on it whether it might be the risk reduction. It doesn't say risk reduction on there. But he says he completed that.
Okay.
And
all we need are the documents to show the proof of completion. So Mr. Williams, you can go ahead and complete the programs that you're required to do as part of your sentence. But then the other part of the job is to bring the documents to the probation officer so they can check it off the box.
And Judge, I do have text messages where the officer unfortunately is not responding.
Okay, isn't he required to report to probation?
He reports online, Your Honor.
May I please?
So when he
So
reports.
let's change the narrative then. I'm going to continue him on probation. I am not going to mark this as a probation violation, so this is not, I'm going to continue him on probation. And he needs to report to probation in person once a month, beginning on December 28th. Before 3 p.m. Clearly, communicating online, text messages and phone calls are not working out. So once a month, he needs to set aside some time and he needs to bring in his alcohol and drug evaluation results and his risk reduction program certificate. We are going to record that he has completed the 100 hours of community service based on the letter that that we just received from council. Anything else, Mr. Finley?
Do you want to say something?
Judge, may I please address the court if possible?
Just briefly.
Sure.
In my correspondence with the probation officer, if you would look at the text messages, it indicates when and what was presented when within the timeline. She never responded to me. If we can go through the text messages, I can then match up all of the sources that were necessary that you guys demanded of me that I did provide. She never responded to me. I was never combative with her. If anything, she was combative with me since the initiation of this probation. I've never received any information, no responses from her. And I often ask her,
May I ask, how is one combative if they do not respond?
when our first, the same way that she stated that I was combative. How was I combative?
No, I'm just asking a simple question. How is one combative if they do not respond?
That was the combativeness. There was no response to any of my inquiries. I asked her.
Okay, so that's an incorrect description. Anything else?
No, Judge.
And Judge, I do appreciate it, and I hope, you know, you respect, you know, me getting.
Like I said, I've accepted that he's done the 100 hours, but you've also got to see the flaws in some of the reporting requirements.
Understood, Judge. So I just want to verify, so he is not going to be revoked, he's going to be released. Is that correct?
Yeah.
Okay.
Correct. This is not going to be recorded as a violation. He's going to continue on probation. And from this point onwards, he reports in person. No more text messages, no more calls.
I live in the state of North Carolina, ma'am.
Once a month.
I lost my job. Okay. Thank you, Judge.
Yeah, Judge, yeah, that's, I guess, the only way. He does live in North Carolina. He does have a 3-week-old, and he has lost his job because he has been detained now. So, you know, this has really negatively impacted his life. He had a full-time job working for a textiles company, making the most money he's ever made in his life. And now
Mr. Finley,
yeah.
I can appreciate the situation is in, but this is a conviction for DUI. I don't know it would. Now, he was allowed to do online reporting. Things went downhill. And like I said, there are flaws on both sides. That's why I'm not recording this as a violation.
Understood, Judge. Understood. I appreciate you. Thank you.
Okay.
1 and
Next,
2,
please.
probations 1 and 2, Mr. Boynton.
Sterrett Boynton. Did I get that right? Sterrett, middle initial L Boynton.
Yes, ma'am.
Okay. Mr. Boynton, you have a probation revocation matter 21 CR 91A, in which the charges were obstruction of a law enforcement officer, battery against a female who is pregnant, and 3 counts of cruelty in the 3rd degree, from which you were convicted of 1 or more of these offenses. And then you have a probation violation matter 23 PV 1705. With regards to these cases, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean.
Your Honor,
Yes,
may I ask Mr. Boynton quite quickly, Mr. Boynton, 250 days remain on the probation, and this probation department plans to recommend that you stay on probation and go to class. Do you need representation today to do otherwise, or are you okay with that?
With that.
Okay, that basically, Your Honor, I think that this will go smoothly. Thank you.
All right, Officer Allison, what is the basis of the revocation?
Yes, Mr. Bolton, he owes probation supervision fees in a total of $160, victim crime funds in a total of $36, failed to obtain a law by committing a new offense of aggravated assault on December 7, 2023 in Fulton County, failed to report as directed on August 8, 2023, August 17, 2023, and September 11, 2023. He failed to complete anger management. He has 258 days remaining on probation. Probation is recommended to continue on probation and enroll in a class within 30 days.
Has he been released on the felony matter?
I don't know if they ever resolved that matter. I have no information on that one.
All right. Mr. McLean, has your client, he's got 250 days left. The question I have is, am I tolling the probation time while he is still incarcerated for a felony matter, or has he been released on bond?
I don't know the answer to that, Your Honor, but with 258 days, that's such a surfeit of days that even if the next couple of months were taken up by the other matter, once released, he would have plenty of time to do anger management. It's not FBIP, so the anger management is probably only how many, 6, 8, or 12?
How many classes has he done, Officer Allison?
I don't have record of him doing any, but he does have to do 8 hours of anger management.
Okay.
So 8 anger management classes.
So he'll
Yes.
be able, once that AA is over with, I think he'll be able to do, assuming there is a release.
All right, let me see.
It looks like he's in no bond status, Your Honor.
I have a $95,000 bond from 2022. Is this a bench warrant matter?
I don't have that information, Your Honor.
That's okay, I'm looking at it right now. Yeah. Oh, it's a new case. Okay. He's not going to be released to complete the rest of the 250 days, Officer Allison. What's the basis for continuing him on probation?
Let me look at the notes for the assigned officer and I can tell you. Based from the assigned officer, they stated that not sure of what's going on with the new offense. If able to be released, can continue on probation and complete the anger management within 30 days.
All right, Mr. McLean, I can mark this as a probation violation matter. I will toll his probation period until he's released on bond. And once he's released, he has additional 250 days left on probation in which he must complete his 8 anger management classes. And those classes must be completed within 60 days of being released.
Yes, Your Honor.
All right. What this means, Mr. Boynton, is that currently you are in jail on a completely unrelated matter. So your probation time, if for this misdemeanor case, is not going to start until you are released from the felony matter.
Yes, ma'am.
And then once you're released, then the clock starts again on the 250 days left. in which you will have to report to probation within 48 hours and then complete 8 anger management classes within 60 days of being released. Start those classes within 60 days.
Will I just be able to provide her the necessary document? I took the class back when I came, and when I get out, I can send it straight over to her.
Well, if you've done those classes, definitely get that proof. And then when you report to probation, bring the proof.
Yes, ma'am.
All right. Anything else, Mr. McLean?
Nothing.
All right, thank you. Please make a note, Officer Allison, the time is told until he's released on his felony case, which, is 23 SC 187930.
I will.
Thank you.
Go ahead, Ms. Milton.
All right, ACDC, who do we have, please?
Position 12, Mr. Kane. He's with the private attorney.
And is this on the SAP calendar?
Yes, Your Honor.
Okay, thank you.
Yes, Your Honor. I was told at ACDC by the defendant that he had some other attorney other than us or other than me. So is his private attorney on?
Kinsey Johnston? All
Right.
right,
He named somebody named Cameron with a 612 number. So a 612 number possibly could be somebody in my office. But
I don't know.
He believed that other person was going to handle this.
All right, Mr. J.J. Montes Damon Kane, case number 20 CR 3372D, accused of simple battery and criminal trespass, family violence from May 20th, 2020. Mr. Kane, you've been advised of your right to remain silent. If you cannot afford an attorney can be appointed to represent you from the Public Defender's Office. But if you have a private attorney or you've hired one, we'll need the name of your attorney. Debbie Milton, if you could unmute, please. This position number 12.
Sorry, Judge, Your Honor. He is my attorney. He is my public defender. I gave him
What is your attorney's name?
him right there. Man.
Okay, he's saying I can be his public defender today, Your Honor.
All right.
He is.
Okay.
All right.
He is.
So
And-
have you spoken with him, Mr. McLean?
We did speak briefly, so we're not going with Cameron, is that right? Did you want to do that guilty plea or the not guilty plea today?
I wanted to do the guilty plea.
Right, that's, I believe, going to be, if I recall correctly, and I'll double check, Your Honor, that is a jail portion of the sentence will be time served.
Okay. So Mr. Kane, as I've indicated, you are charged with simple battery and criminal trespass, family violence. You have been advised of your right to remain silent. Your attorney is Mr. McLean. For purposes of the plea, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Pierre Thomas, what's the plea recommendation for Mr. Kane?
Your Honor, the recommendation from the state is a time served offer. It's for the defendant to serve 365 days on the count 1 simple battery, credit for the 398 days that he's already served in custody, and on count 2 criminal trespass, family violence, for the defendant to serve 365 days credit for the 398 days that he's already served. Your Honor, it looks like our office was at some point able to get in contact with the victim, Darnasha Kane. She advised that she was aware that the defendant had been in custody for a long time. She states that she's okay with the defendant pleading at this time and to time served and receiving a no further violent contact with her sister. If we can at this time sound for the victim in accordance with Marcy's law, that we greatly appreciate it.
Darnasha Kane? All right. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do, Your Honor.
All right. Mr. Kane, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings with regards to this case?
Yes, ma'am.
Are you satisfied with your discussions and your representation from Mr. McLean?
Yes, yes, ma'am.
And is anyone forcing you to enter a guilty plea today?
No, ma'am.
Are you doing so freely, willingly, and knowingly?
Yes, ma'am.
And in that respect, do you understand that you'll be waiving your right to a trial? You will not be able to go back to court to challenge these charges in a court of law. You will not be able to confront your accuser and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery and one count of criminal trespass, family violence?
Yes.
Your sentence for both these charges is to serve 365 days, credit for time served 365 days. Your jail obligations on both these charges are completed. And, well, I can't impose any conditions since you've already served out your sentence for these two charges. But if you have any violent contact with Danisha Kane, you could end up being arrested again for a new offense. Do you understand?
Yes, ma'am.
All right, good luck. Thank you.
This is gonna be on the probation calendar.
There's no probation, he's completed.
Oh, no,
I'm
she's
sorry?
talking, the deputy is talking about the next case.
Oh, which case is
Position,
that?
position number 28 and 29, Larry Sims.
I was getting ready to do it now, but.
Okay, still with us, Brian.
Mr. Larry Sims is, okay. Case number 23 CR 1126H, in which Mr. Larry Sims has got the following offenses: DUI, less safe, impeding traffic flow, seatbelt violation, possession of an open alcohol container, driving while license suspended or revoked, willful obstruction of an officer, and failure to have license in person. The second case he has is a bench warrant matter, 23 FTA 1080. Mr. Sims, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Finling. Do you see Mr. Finling on the screen?
No, ma'am.
You don't?
Yeah, I'm right here, man. Judge, I did need to ask him a brief question. I don't know if I could, it would literally take about 30 seconds. I don't know if I can.
All right.
Really quick.
Sure.
Excuse, what position was this on probation? I don't have a
No,
Larry
this is
Sims.
this is the SAP calendar, positions
Oh,
28.
I'm sorry. I thought I heard probation.
That's all right, thanks. Mr. Finling, if you have your laptop open by any chance?
Yes, I do.
All right, are you
Yeah,
have you joined Zoom?
I'm not on, I'll log on my laptop right now.
All right. As soon as you're logged on, we can put your laptop and jail court iPhone in a breakout, and we can do the next case with Mr. McLean.
Okay. I'm gonna use Rachel Abden, who's right here. PD, it says PD Rachel Abden.
Okay.
This is gonna be on the probation calendar, numbers 9 and 10. Mr.
Okay.
Ricky.
Ms. Grace, you're gonna, as soon as Mr. Finling gets on PD Rachel Abden's laptop, you do see it on the Zoom? Could you place?
Yes.
Could you place Rachel Abden and jail court iPhone in a breakout, please?
Jail court iPhone and Rachel Abner. Yes, ma'am.
All right, we just have to wait for Mr. Finling to, okay. We're going to jail court iPhone. Deputy, could you mute your screen until, and then you'll see a message on your screen to join a breakout. That's for jail court iPhone. And PD Rachel Abden, who looks remarkably like Zach Finling. All right. Mr. McLean, is your client Lamar Ridley?
Your Honor, he's in Cobb County on our Fulton County custody. So he, because of the recommendation, because of what he would be best off in proceeding with in terms of presentation, he would like to request a reset.
Okay, so Lamar Ridley is going to be reset to December 28th. Probation revocation calendar.
Thank you, Your Honor.
And that's 7, 8, 9, 10.
Okay, you're all set.
Okay, who's the gentleman next to you, sir?
That was Mr. Ridley.
Okay, thank you.
It'll be set next week.
All right,
Okay.
what's the next case for courtroom 2?
Mr. Beaver.
Is that
Beaver,
Mr. McLean's client?
number 2.
That'll
No.
be 7.
Oh, that's Ms. Adams? Okay, hold tight, your attorney's not in.
Does Mr. McLean, do you
Mr.
represent anyone at ACDC?
Mr. Thornton.
Oh, you've got someone? Okay.
Mr. Thornton, number 31.
Is that Mr. McLean's?
No, Thornton is not. No, that's not McLean. I'm McLean. Oh, that's Mr. Finley. Yeah, that's what I thought.
Mr. McLean has positions 1 and then 8 to 18.
Okay, let me go back and.
So there were several
Come on,
people.
Mr. Hill.
One person who was at
Hill.
ACDC was last name Cato.
Come on up, Miss Cato.
I can see him.
Miss Cato, okay.
Yes, who have I got? Anyway.
Ms. Cato is position 13, and that is going to be an arraignment and a bond hearing. Would that be correct?
Correct.
All right. Ms. Shavante Cato, my name is Judge Lal, and we are addressing position 13, 23 CR 7772C, in which you are accused of battery family violence from October 20th, 2023. You've been advised of your right to remain silent, and your attorney is Mr. McLean, who is located in courtroom 2. Do you see him? Okay. With regards to this particular charge, the prosecution has requested a transfer to the district attorney's office for the offense to be tried as an aggravated battery charge. Mr. Pierre Thomas, what's the status of that request?
We're still in the process of waiting for it to be accepted, Your Honor.
All right. So in the meantime, Ms. Cato, I'm going to arraign your case. Mr. McLean, do you waive a reading of the accusation?
We do. We have a copy. We've looked at it.
All right. ACDC, if you could please unmute. Ms. Cato, as I've already indicated, you are charged with a misdemeanor offense of battery family violence. The prosecution is seeking to have this matter transferred to the DA's office as a felony. It has not been transferred, so we are still treating this as a misdemeanor case. You are represented by counsel, and based on your counsel's announcement, upon your entry, upon your statement of a not guilty plea, this misdemeanor case will be further noticed for a trial. At the time of the trial, the prosecution would have to try this case as a misdemeanor, and the prosecution has the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the prosecution does prevail, you could be convicted of this misdemeanor offense and face a penalty of up to a year in prison and or up to $1,000 fine. This would be a misdemeanor conviction, and therefore any chances of it being transferred as a felony would then be would not happen. So given this information, how do you plead to the one charge of battery family violence? Repeat.
Guilty.
Well, this would be a change. We were pleading not guilty yesterday.
No, I said not.
No offer.
I said
no
not
offer.
guilty.
Okay, sorry. We all
I
heard
didn't
guilty,
hear that.
but I think she meant not guilty. Is that correct, Ms. Cato?
Yes. Yes,
All right.
ma'am.
Your case is arraigned and further notice for trial. Presently, you do have a bond in your case. And Mr. McLean, what are we seeking? The bond was set at $2,000 on December 7th.
Your Honor, That is that 2 or 3? My print is so small here.
It's 2.
That's a 2. Yes, it is 2. We need different printers. Your Honor, with the $2,000 bond, I don't think her record is extensive at all. We could have the clerk or the prosecutor read the record of any arrests she's had in the past. But she's asking the court to consider a signature bond or at most a $1,000 good bond.
Mr. Pierre Thomas?
Your Honor, our records indicate that she has 2 cycles. The last conviction was 2016 for public disorderly conduct out of South Carolina. Our stance on the matter is, given the nature of the charges and the idea that this is being sought to be upgraded as a aggravated battery, it's alleged that she basically disfigured the nose and the teeth of an individual, or the victim in this case. In addition to that, it's alleged that she did so by use of an object. The state believes that a $2,000 surety bond is more than reasonable at this point.
I was the individual who presided over the initial appearance, and the victim did appear and confirm that he was injured on his nose and his teeth. Mr. McLean, I thought that bond was reasonable. And given the nature of the charges and given her prior history, I'm not certain why I'm modifying the bond.
Right, that DC from Charleston was 7 years ago, Your Honor. So we would seek a signature bond or a $1,000 bond basically on that basis.
All right, bond modification is denied. This case is going to be further notice for trial. Thank you. All right, going back to Mr. Findling and Mr. Sims.
And Judge, this is going to be a plea. There was just a small thing I was going to ask. I'm not sure if that would be non-negotiable.
All right, Mr. Findling. Mr. Sims, could you please, I'm not sure if you placed you under oath, but let me do it again. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Okay, Ms. Pope. Let's
Yes,
see
Your Honor.
now. Count 2 is going to be null cross. Count 3 is going to be null cross. And count 6 is going to be a consecutive to count 1. And just I'm trying to make sure I get all these information. Count 7 is going to merge with count 5. So what we're looking at is the remaining charges of DUI under the influence of alcohol less safe, possession of an open alcohol container, and driving while license suspended or revoked. What is the plea recommendation for these 3 charges?
And I have 4 charges, so maybe something.
Oh, 1, 2.
So I have count 1, 12 months probation, served 56 days, credit for time served 28 days from 11/24/2023, balance probated, ADET, risk reduction, $300 fine, 40 hours community service, and 1 victim impact panel. As you stated, count 2 is null pros, count 3 is null pros, count 4, 12 months probation, $200 fine, concurrent with count 1, count 5, 12 months probation, excuse me, $500 fine, concurrent with count 1, and count 6, 12 months probation, consecutive to count 1. Count 7 does merge with count 5. Total offer is 24 months, serve 56 days, credit for 28 days. Since 11/24/2023, balance probated, ADET, risk reduction, $1,000 fine, 40 hours community service, and 1 victim impact panel. And of course, 28 would be dismissed upon plea to, 29 would be dismissed upon a plea to 28.
Okay, and you're right. It is 4 charges. I missed out on willful obstruction. Ms. Cato, we are done with your case. Your case has been arraigned and further notice for trial. Oh, I'm just waiting on Deputy Milton to mute that screen. Oh, Miss Grace, you can mute ACDC, please.
Oh, that's Thank you.
Okay,
got it. Got it.
mute them. Oh,
Yeah, got it. We got it. Thank you. All right, Mr. Finling, so yes, it would be, the proposed plea offer will be respect to counts 1, 4, 5, and 6. And do you stipulate to the factual basis, venue, and ID for these 4 charges?
Do so stipulate, Your Honor, and Mr. Sims has agreed and understands of the 24-month probation, all the classes he has to take. The only thing I wanted to ask, Judge, is finances are an issue in his life. He has no money to his name. So for the $1,000, if there's any way that could be converted into $100, 100 hours of community service. I know sometimes we do the each $100 is 10 hours of community service. I want to see if he'd be willing to do that, Your Honor.
Ms. Tyson, how many prior DUIs convictions does Mr. Sims have?
One moment, Your Honor. You said prior the DUI convictions?
Yes.
Okay.
So this sentence is definitely not for a first-time DUI. Unless it is.
He was receiving credit for time served, essentially on the jail time, but the rest of it appears, just make sure.
Yeah, he has a couple driving while license suspended or revoked, but I'm not seeing, let's see.
So is this the first time lifetime DUI?
And Judge, because I just got his information late yesterday and I came to see him, I don't have his GCIC.
That's why I'm asking Ms. Tyson if this is first or prior.
I see an arrest from from 2020. No dispositions listed for that for a DUI. Let's see, he had a DUI that was dismissed May 3rd of 2023. And then the arrest that's on the calendar that it said it was let's see. Yep, and this one, so no convictions for DUI, just a couple arrests and 1 dismissal.
Okay. Mr. Finling, considering that he's going to be on probation for up to 24 months, I'm not going to amend the $1,000 fine. And he'll have up to 24 months to pay off that fine.
If I may ask, Judge, because I've seen a lot of first-time DUIs where it's pretty much all of them I've seen, at least at SAP, are 12 months. So it was my understanding, just like you, Judge Law, that it seemed as if this was his second DUI. So if it's
it was because he's got a $500 fine on driving while license suspended or revoked, and this is a multiple offender for this particular offense.
Okay. Understood.
So, Mr. Sims, I am not amending your $1,000 fine to community service. You would be required to pay a $1,000 fine and do 40 hours of community service, and you have up to 24 months, less 42 days to complete these conditions. Would you still like to proceed with this plea, or would you like to have a trial?
Yes, ma'am, I would like to proceed.
Okay. Mr. Sims, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Is anyone forcing you or inducing you to plead guilty today?
No, ma'am.
And have you understood, are you satisfied with your attorney?
Yes, ma'am.
Has it been explained to you that if you plead guilty to these charges, that it will show up on your driving history? This will be marked as your first lifetime DUI conviction. Has it been explained, and are you willing to accept that?
Yes.
And do you understand that this will add points to your driving history and also suspend your driver's license?
Well, I thought my license already was suspended for a year behind this case.
Understood, but this DUI conviction will also suspend your driver's license for additional time, so you won't be able to seek reinstatement immediately.
How long would it be suspended if you don't mind me asking?
I believe it'll be up to a year.
Mr. Sims, so I've gotten to have a better understanding by asking my supervisor, so I'm gonna call you once you get out and we'll talk about the steps you can take.
Okay.
All right. And furthermore, has it been explained to you that if you decide to plead guilty, that you will not have a trial? You will not be able to come back to court to confront your accuser, to be able to challenge the evidence brought against you, to be able to present any defenses or mitigating factors if you choose to do so, and to have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of driving under the influence of alcohol and possession of an open alcohol container?
Am I able to plead NOLO?
I'm not accepting a NOLO. I've not heard that that was the agreement with prosecution. Ms. Pope, was there an agreement to plead NOLO?
No, Your Honor, there was not.
Mr. Sims, how do you plead to driving under the influence of alcohol and possession of an open alcohol container?
Guilty.
How do you plead to one count of driving while license suspended or revoked and willful obstruction of a law enforcement officer?
Guilty.
On the DUI, DUI driving under the influence of alcohol less safe, your sentence is 12 months to serve 56 days. Credit for time served, 28 days. If you have no other holds, you report to probation next Thursday before 3 p.m. The probation office is at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete an alcohol and drug evaluation, a risk reduction program, pay a $300 fine, complete 40 hours of voluntary community service at any nonprofit agency, which is not a church and not a school, and attend one victim impact panel. With regards to count 4, possession of an open alcohol container, your sentence is 12 months, probation to pay a $200 fine, and this will be concurrent with count 1. On the driving while license suspended or revoked, your sentence is 12 months probation to pay an additional $500 fine. The remainder will be concurrent with count 1. With regards to willful obstruction of a police officer, your sentence is 12 months probation consecutive to count 1, which is why you're on probation for up to 24 months. In total, your probation is up to 24 months, in which you would report every month. You would be completing the programs I've outlined, including paying up to $1,000 fine and doing the 40 hours of community service. Any questions, Mr. Sims?
No, ma'am.
All right, thank you. That completes, and your bench warrant will be null pros. Mr. Pindling, who do you have next to you?
This is on the probation calendar, number 3 and 4, Mr. Hill.
That's the gentleman in courtroom 2?
Yes, it is, Judge.
All right. Mitchell Hill has got a probation revocation in case 20 CR 2228E, in which he had been accused of battery, substantial physical harm, criminal trespass, and theft by taking, of which one or more of these charges were a conviction. Position 4 is the probation violation matter 23 PV 1706. Mr. Hill, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Officer Allison, you have been deemed under oath. What is the basis for the revocation?
Yes, Mr. Hill owes probation supervision fees in total of $520, victim crime funds in total of $117, failed to complete 150 hours of community service, He has 163 days remaining on his case. Probation is recommended for time served. Please close.
Mr. McLean, this will be recorded as a violation. Do you agree with the recommendation?
Yes, Your Honor, he understands, we've discussed it, and he concurs.
Mr. Mitchell, your cases are going to be recorded as a violation. Your sentence is going to be commuted to time served, and your obligations for this case is closed. Thank you.
Thank you, Judge.
Next, we have position 16, Ms. Laverne Gord.
Deputy Milton, you have to unmute the terminal, please.
Oh, that's number 4. Yeah, that's what I.
Position 16, Mr. McLean, this is Laverne Corday. Is that how you pronounce your last name? Corday. 23 CR 7824G, accused of battery from December 8th, 2023. Ms. Corday, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Do you see him on the screen?
I believe so.
All right. Mr. McLean, what's the announcement for this position?
Your Honor, I believe this should be referred to another court. I believe that court might be meeting today.
Okay, at 11 a.m.?
Yes. Not DBBW, but yes, Your Honor.
Ms. Corday, have you spoken to your attorney, Mr. McLean?
Yes, I have.
All right. We will be addressing your case later on at 11 o'clock. Thank you.
Thank you.
Next is position number 14 and 15, Antonio Cloud.
Thank you.
Those both are pleas, Your Honor.
Thank you. Antonio Cloud is accused of criminal trespass in case 23 CR 6897B and loitering and prowling in case 23 CR 7603B. Mr. Cloud, my name is Judge Lal, and you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean is in courtroom 2. Do you see him on the screen?
Yes, ma'am.
Thank you. This is going to be a negotiated plea hearing. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Pierre Thomas, what's the recommendation for both these cases?
Your Honor, the recommendation for the case ending in 6897B is for the defendant to serve 12 months on probation, to serve 90 days in custody, credit for the 27 days that he's already served. Looks like he was booked in on November 4th and released on 2023 and released on November 7th, 2023, and then rearrested on November 29th, 2023. It's for the balance to be probated. It's for a stay away from the shopping center located at 576 Lee Street Southwest, for him to have no further contact with James Theron, Theron, Margaret, Morgridge, and also Margaret Andiga, Andega, and for restitution to remain open for 30 days. If we could sound from Ms. Andiga and Mr. Morgrid, that'd be greatly appreciated. Mr. and Mrs. Morgrid, that'd be greatly appreciated, Your Honor.
All right. Well, you've just called out the name, so I'm not going to attempt to butcher it. But I don't see anyone responding to that name, but I do see the alleged victim for the second case.
Sure, Honor, we do have intel that Ms. Fox is on. The recommendation for the case ending in 7603B, loiter and prowl, the recommendation is for the defendant to serve 12 months on probation, to serve 82 days in custody, credit for the 16 days that he's already served. Looks like he was booked in on November 29, 2023, for the balance to be probated, for there to be a stay away from 979 Arden Avenue Southwest, for the defendant to complete an anti-theft course, to complete 40 hours of community service, and to have no further contact with Ms. Crystal Fox. That is to be served concurrently with the case ending in 6897B. That's a global recommendation. Your Honor, I do believe that Ms. Fox is on, so if we could have her speak at this time, that'd be greatly appreciated.
Crystal Fox, I see you're present on Zoom. If you want to contribute to the proceedings, you need to unmute and start your video. Crystal Fox. All right. While we're waiting, Mr. Pierre Thomas, what about the restitution requirement for position 14? Is that still?
I think we have to leave it open. We haven't received a specific amount for the items that were damaged.
Okay. Ms. Fox?
Yes, Your Honor, I don't see how to do the viewing, but I was able to unmute.
Ms. Grace, if you can send Crystal Fox a prompt to start video.
Last row, sit in the second row.
I did, Judge.
There we go.
Okay, there we are. Thank you so much.
All right, Ms. Fox, did you hear the recommendation by the prosecutor with regards to Antonio Cloud involving a loitering and prowling charge?
Yes, ma'am, I did. I did want to ask at the, I don't know, the other hearing, the judge recommended that he stay away from me and my property next door because he climbed from my other property, 973 Arden, over into 979. And I would like that included in his distancing himself from me.
No
Is
objection.
973 within 200 yards of your location? In other words, is it within 2 football fields?
Yes, ma'am, it is. It's right next door.
So he would be required to stay 200 yards away from 979, so which would incorporate your adjacent neighbors as well.
Yes, ma'am. And also, I wanted to ask you, Your Honor, if I have his bag that he left on my property. I didn't know how to dispose of it.
You can bring it down to the police station.
Okay.
If you want.
Do we know which precinct would that be, 1 or 2 or 3 or?
What's the closest police station to you, Ms. Fox?
I'm not certain. Sorry.
All right, Ms. Fox, if you can let Victim Advocate's Office know.
Yes.
Which police station you plan to drop the bag off. Then
Okay.
Mr. McLean, you can reach out to Victim Advocate and Victim Advocate can communicate that information to Courtroom 2, not Courtroom 2, to Mr. McLean, who can then advise his client where to get his belongings.
Right, Your Honor. I have the usual second half of my email is the same, fultoncountyga.gov, but I use MIKE dot, my last name, MCCLAIN. I don't use Michael, I just use Mike for the email.
Okay.
Thank you.
All right. Anything else, Ms. Fox?
One last question. I am a recognized figure in the community, and one of the other things the judge forbid him to do was to reach out to me on social media. Can that happen as well, or no?
If no contact with you means that he has to stay 200 yards away from you. He cannot communicate with you in person, through a third party, through a computer, through a cell, and even on social media.
Thank you very much, Your Honor. I appreciate that.
Okay. All right. Thank you, Ms. Fox. You may mute your screen.
Thank you.
Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do, Your Honor.
All right. Mr. Cloud, you have 2 open cases with us. One is for criminal trespass at the shopping center at 576 Lee Street and one at 979 Arden Avenue. Are you familiar with both these cases?
I am.
All right. And Mr. Cloud, have you consumed any medicine or alcohol today?
No, ma'am.
So you're able to understand everything that's been going on so far?
Yes, ma'am.
And are you satisfied with your attorney?
I am.
And has he explained all the terms of the sentence if you decide to plead guilty to these 2 cases?
Yes, ma'am.
And has he explained to you that if you decide to plead guilty to the charges in these two cases, that you will not get an opportunity to have a trial? You will not go back to court to face your accuser in front of a judge or a jury. You will not be able to challenge the evidence brought against you, have an attorney to challenge the case in a court of law, and also have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
And do you understand that you do not have a right to appeal this decision once I impose your sentence?
Yes, ma'am.
How do you plead to one count of criminal trespass from November 3rd, 2023?
Guilty.
With regards to that conviction, your sentence is 12 months to serve 90 days, credit for time served 27 days. It appears that you have about 28 more days to serve at the jail. Is that your understanding?
Yes, ma'am.
And after that you've completed the additional time at the jail, you will report to probation at the first available business day, which will be a Monday, Tuesday, or Thursday. Miss Grace, could you stop the video for Miss Fox? The moving around is very distracting. Thank you. As I was saying, you'll be on probation. You'll report to probation at 132 Mitchell Street in downtown Atlanta. While you're on probation, you are to stay away from the entire shopping center at 576 Lee Street. You have to have no contact with James and Trevon Morgridge, and you need to come back to court when summoned in order to have a restitution hearing. That restitution hearing must be scheduled within 30 days from today. If it's not scheduled within 30 days from today, then there will be no restitution awarded. Do you understand, Mr. Cloud?
Yes, ma'am.
All right. How do you plead to one count of loitering and prowling from November 29th, 2023 at Arden Avenue?
Guilty.
Your sentence is 12 months to serve 82 days, credit for time served 16 days. You will have additional time to serve, and this is concurrent to position number 14. Once you've completed your jail time, you will report to probation. And while you're on probation, you will stay away 200 yards away. That's the length of 2 football fields from the house located at 979 Arden Avenue in Southwest Atlanta. While you're on probation, you will also complete an anti-theft class, and you must do that class within 60 days of reporting to probation. You're also to complete 40 hours of community service. As I've already explained, you are to have no contact with Crystal Fox, which means staying 200 yards away from her and not communicating with her in any way, form, or manner, including social media. Do you understand, Mr. Cloud?
Yes, ma'am.
If you violate any of the conditions of your sentences in both cases, your probation can be revoked and you can be sent back to prison to serve out the rest of the 12 months. Thank you.
Yes, ma'am.
All right, Mr. McLean, who is seated next to you?
Judge, we're gonna do all the, finish up with ACDC, and then we'll come back to courtroom 2.
All right, ACDC, who do we have seated there?
There we have position 25, Ms. Quinetta Jones.
All right.
This is State versus Jones, charged with criminal trespass under accusation 23 CR 6054E. Ms. Quinetta Jones, this is an incident from October 8th, 2023. You have been advised of your right to remain silent, and your attorney is Mr. Finley.
Your Honor, she actually has 2 cases. I'm not sure if you're going to do both of them at the same time, but she's position 25 and 26.
Oh, thank you. I did not know that. Okay. Is Mr. Findling available?
Yes, Judge.
All right. So as pointed out, Ms. Quinetta has a second case, 23 CR 7792E, in which she's accused of theft by taking from December 27th, 2023. So Mr. Findling, what are we doing with both cases?
Yes, Judge. So, to position 25, that's going to be a negotiated plea. And then to position 26, non-negotiated, just so I could very briefly address, jail time.
All right. Just going to treat both of them as a non-negotiated since that's going since position 26 is concurrent to position 25. So Ms. Jones, I'm first going to hear from the prosecutor as to what the recommendation is if you decide to plead guilty to both cases. And then I will hear from your attorney. I will let you know which option I will select, keeping in mind that I also have the right to disregard either option and schedule the case for trial. So may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Pope?
Yes, Your Honor. On case number 23 CR 006054E, the recommendation for the criminal trespass was 12 months probation, or is 12 months probation, served 34 days, credit for time served, 17 days from October 8th to October 9th, and from December 7th. Balance probated, stay away from all MARTA facilities. And case number 23 CR 007792E, 12 months probation, 60 days credit for time served from December 7th, 2023. Balance probated, anti-theft course, no further contact with Renee Bell, stay away from all MARTA facilities, buses, or all MARTA facilities, and to run concurrent with 23 CR 006054E. The additional jail time was requested on October 8th. This was just 2 months later. There was an allegation that she did steal a wallet while on a MARTA train from Renee Bell. In addition to the allegations, Miss Jones has 18 cycles. She has a conviction for criminal trespass, battery, family violence, criminal trespass, simple battery, probation violations. In 2022, she has a criminal trespass and a possession of drug-related object conviction just from last year. So there was an enhancement based on while on bond, she was back on another MARTA train and stole a wallet from the victim, Renee Bell.
Just to clarify, position 25, you indicated balance probated. I've got a note here, balance suspended. Is that a typo?
I'm sorry. Yeah, balance is, that's fine. Balance suspended in the criminal trespass, but balance probated in the theft by taking. Thank you for that correction.
Mr. Findling, so your client is okay with the recommendation for position 25. What's the issue with position 26?
That's correct, Judge. And just quick question. So for the allegation relating to the wallet, is that a charge? I'm just like looking at her screen. I just want to make sure I'm seeing it. Was she?
It's the theft by taking, and it was a theft by taking on a MARTA bus where the allegation was the victim, Renee Bell, was her person sitting there. I'm sorry, go ahead.
I apologize, Ms. Pope, but is the allegation that you're referring to different from this case, or that you're talking about this case?
Oh, this case. I'm sorry. No, the present case.
Understood. Yes, Judge. Ms. Jones, Quinetta is a 29 judge, has 2 kids that do live with her. She plays a big part in their life, and quite simply, they need her, especially going into the holidays. Judge, I'm asking for time served. She served 15 days. The state is asking for 15 additional days. On the criminal trespass, she had a signature bond. On the theft by taking, she has a $500 surety bond. So while I hear that they want her to spend 15 more days in her 8x8 foot cell, they're obviously okay with her paying, which is ultimately after a bonding company with taxes would be about $60, $70. So now, while bond is not meant to be punitive, it has become punitive, and it's punishment for being poor, which is a whole nother story, but Judge, she's in there for $60-70. Now she's taking a plea. We're asking for 15 more days. So there clearly isn't that big of an issue of her getting out. So, Your Honor, a $500 bond is, I think we can both agree that someone not being able to pay $60-70 to get out for the holidays is extremely sad and unfortunate, and it's punishment for being poor and having poor friends and family. So on that count, Your Honor, I am asking for her to get time served so she can be with her family, be with her kids for the holidays, and not be stuck in a cell for $60-70.
Would it have been different if it wasn't the holiday season?
No, it wouldn't,
Okay.
Your Honor, I think.
Just want to be sure. Thank you.
Aside from the holidays, I think the biggest issue is that she has a $500 bond, which is effectively $60-70. She's stuck in there for being, it's punishment for being poor.
Any response, Ms. Pope?
I'm not gonna comment on who gave the $500 bond or who requested the $500 bond with this criminal history and 18 cycles. It certainly wouldn't have been this prosecutor's request for a $500 bond. Looking at the facts and circumstances of the case, in addition to her criminal history, there were other arrests that I did not mention, but I just went off the convictions. That was the reason for the state's recommendation.
Since the recommendation involves Ms. Jones being on probation for the theft by taking, I will amend the time to 12 months to serve 30 days, credit for time served 15 days. But she will be on active probation for the rest of the 12 months, where she's not only required to take the anti-theft class, but she also has to have no contact with Renee Bell. And unfortunately, while she's on active probation, she cannot use any MARTA facility, the buses, the trains, the stations, and so forth. If she violates that and she's arrested again for going back on a MARTA property, her sentence, her probation can be revoked, and she might end up serving a lot more than 30 days in a Fulton County jail.
Understood, Judge.
Ms. Cornetto, is that something you'd like to consider?
Yes.
And you understand that you have to stay away from all MARTA property for 11 months?
Yes.
Okay. Mr. Finding, do you stipulate to the factual basis, venue, and ID?
Do so stipulate, Your Honor.
Mrs. Quinetta, have you consumed any medicine or alcohol recently?
No.
And have you understood the proceedings so far?
Does that mean that I get out today?
Well, it means you get out today, but you can't use MARTA and you're on probation for 11 months. That's what it means.
Okay. Okay.
Well, within 24 hours, let's put it that way.
Okay.
And are you satisfied with your attorney?
Yes, I am.
Is anyone forcing you to plead guilty to criminal trespass and theft by taking?
No.
So are you pleading guilty to these charges because you are in fact guilty of these offenses?
Yes.
And has it been explained to you that if you decide to plead guilty, that you will not have a chance to a trial? You will not be able to go back to court, confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt?
Yes.
How do you plead to one count of criminal trespass?
Yes.
Your sentence is 12 months to serve 34 days, credit for time served 17 days, balance suspended.
Yes.
Stay away from all MARTA property. How do you plead to theft by taking from December 7th, 2023?
Yes.
Your sentence is 12 months to serve 30 days, credit for time served 15 days, balance probated. You'll be released within 24 hours. You have to report to probation next Thursday, December 28th, before 3 p.m. Once you report to probation, you will be on active probation for the rest of the 11 months remaining on your sentence. You will report every month. You are to have no contact with Renee Bell. You have to stay away from all property belonging to MARTA, including their buses, the trains, and the stations. And you are, and that's it. Oh, you're supposed to take the anti-theft class too. I thought I forgot something. and you must enroll in that class within 60 days of reporting to probation. Thank you.
Thank you, Judge.
Position number 27, Mr. Paul Riley.
Mr. Paul Riley, is that the gentleman at the jail court iPhone?
It is.
Mr. Riley, your case is 23 CR 7793A. You're accused of battery, family violence from July 10th, 2023. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Finling. Mr. Finling, this is going to be an arraignment. Do you waive a reading of the accusation?
I do, Judge.
All right. Mr. Riley, upon your entry of a not guilty plea to the charge of battery, family violence, allegedly occurring on July 10th, 2023 in Fulton County, Georgia, your case will be scheduled for trial. At the time of the trial, the prosecutor would have the burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state does succeed, you could be convicted of this offense and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Your case has been arraigned and further notice for trial. Thank you. ACDC, who do we have? What's your name, please? ACDC. The young lady at ACDC, what's your name, please? Mr. Finling, do you recognize this person?
I don't, Judge. That's not my client.
Mr. McLean, is that your client?
I'm sorry, which case are we on here?
The young lady at ACDC.
In the top left.
What is,
Do you recognize?
what is the name?
I don't know. Ma'am, you're seated at ACDC in front of a computer in a large room with white chairs behind you. Look behind you.
Her last name is Upshaw.
Are you Miss Upshaw?
Yes.
Okay. Well, she is exercising her right to remain silent, so it's perfectly fine. Okay. Mr. Finling, that's Miss Upshaw. By any chance, do you represent her?
I don't represent Ms. Upshaw, Judge. Let me just take a quick look. Does anybody know where she is on the calendar?
It's Crystal Upshaw. She's on probation.
Okay,
11 and
thank you.
12.
Thank you.
We're good. We can proceed. She's yeah. Ready.
Continue getting the class within 30.
Mr. Finling, would this be your client that you need to speak with, or?
If I could just briefly speak with her, Your Honor.
All right, you would need to procure Ms. Abden's laptop again.
Okay.
So I can put you in a breakout. Deputy Milton?
Yes,
Deputy
Your Honor.
Milton, we're going to put the screen in front of Ms. Upshaw in a breakout with attorney Mr. Finling. Ms. Abden, I hope you're getting lots of chocolate for having to use your laptop for others, but
I hope so too, Judge.
all right.
Yes, Your Honor.
Your Honor, I was going to say, Your Honor would be shocked to learn that we all have computers today.
All right, Mr. McLean. Miss Grace, if you can place jail court, ACDC jail court, and PD Rachel Abden in a breakout, please. All right, Mr. McLean, is that your client seated next to you?
Meanwhile, Judge, we're gonna do position 2. This is Beavers. That's yours?
Yeah.
And I should.
Miss Abden, would you be able to come into courtroom 2, please?
She's in it.
Thank you, Ms. Abden. All right, we have Merrill Leon Beavers in courtroom 2, accused of criminal trespass under case 23 CR 7236Y, allegedly from November 20th, 2023. His second case, position 3, is case 23 CR 7465 Y, accused of criminal trespass and disorderly conduct from November 27, 2023. Mr. Beavis, you've been advised of your right to remain silent. Anything you say, your statements can and will be used against you. You have a right to an attorney, and Ms. Rachel Abden will be representing you. Ms. Abden, what are we doing with respect to this two cases?
Your Honor, I was going to ask that this be handled in a breakout room. It's going to be a non-negotiated plea, just to the MHET requirement. I wanted to discuss that in the breakout room.
All right, that would be difficult given the audience behind you, unless Mr. Beavis is placed in a different location.
Can we hold until the end of the calendar, Your Honor?
I guess so.
So the best thing to do is take the laptop. Just take a little look out.
Okay, Your Honor, yeah. Would it be possible for me to use my laptop and discuss the MHET requirement?
As long as courtroom 2 and the deputies can provide the necessary security around your while you're on the laptop, that's perfectly fine with me.
She'll go to a different location. She won't be able to go to.
Yeah, there's another room out there.
Okay. I will wait for Mr. Beavis, but I'm going to let you confer with the deputies on how he's to be relocated to address this as a breakout session.
Thank you, Your Honor.
All right, thank you.
Number 31, Thornton.
And that's my case, and I'm also gonna give Miss Abden back her laptop and log on to Zoom on my computer so I can speak with the other.
Mr. Abden, have you conferred with ACDC? Mr. Finling, not Mr. Abden.
Yeah. So we're not done.
Can we do position number 22?
22 is Mr. Finling's client.
We can do that. And also Thornton's also much I can do.
Okay. Mr. Finling, have you spoken to Ms. Upshaw at ACDC?
I haven't, Judge. I mean, I would just be talking to her super briefly just to tell her what she didn't do, kind of read it to her. But no, I have not.
I'm sorry, you were breaking up. Have you had a chance to confer with Ms. Upshaw in a breakout session?
No, I haven't, Judge. They didn't, I wasn't put in a breakout room, but that should just take a second.
Okay. And are you ready to proceed with Eric Garrison? He is at the jail court iPhone.
Yes, I am, Judge.
Okay. Eric Garrison, if you are Eric Garrison at jail court iPhone, please raise your right hand. Thank you. Your case number is 23 CR 7889A, in which you are accused of battery and cruelty in the third degree from September 29th, 2023. Mr. Garrison, you have a right to remain silent about the facts of your case. Any statements you make, they can be used against you. You have a right to an attorney, and representing you is Mr. Zach Finling. Mr. Finling is the attorney in the light gray suit in courtroom 2. Do you see him?
No, I can't see anybody.
Okay, Deputy, you may have to slide the screen on the iPhone so you can see multiples.
Hold on, let me get you the next person. Give me 1 second.
Okay, you see him? Okay. All right. So Mr. Finling is your attorney. This is going to be a non-negotiated plea hearing, which means that Mr. Garrison, you have to make a decision as to whether you want to plead guilty based on the recommendation that's going to be presented to you. The prosecution is going to give me one recommendation, and your attorney is going to give me a different recommendation, after which I will let you know which one I'm going to select, keeping in mind that I can disregard either option and have the case scheduled for trial. Do you understand, sir?
Yes, ma'am.
Thank you. Ms. Pope, what is the state's recommendation?
On count one, 12 months probation, served 44 days, credit for time served 22 days since December 1st, 2023, balance probated, 12-week anger management, 40 hours community service, no further contact with Carolyn Garrison, and stay away.
And count two is
I'm sorry,
concurrent?
count two is 12 months probation concurrent with count one.
Okay.
Yes.
Mr. Finling, what is the defense's position?
Yes, Judge. I was just asking for there to be no stay away and also for to be no further violent contact. That address is where he is going to be living. His sister, who's also on the Zoom, is not living at that address anymore. So they wouldn't be together at that address. And also Miss Garrison, Mr. Garrison's sister does want to have contact with him. And I know she wanted to come on and say that for herself. That's okay with you, Your Honor.
Okay. Carolyn Garrison, if you are present, please unmute and start your video. Carolyn Garrison, do you see her on Zoom?
So she texted me and said is that a coincidence that there's a Allison Garrison in the bottom right? Is that?
I think that's court staff.
Okay.
Unless. Is victim advocates present? Miss Imani or Miss Maldonado?
They're not present. I can tell you that we did reach out to Miss Garrison, or we attempted contact and requested a call back and have not been able to speak with her.
All right.
If I could, I know she texted me at 10 a.m. saying that she was, I guess, she was driving, she had to log off. So I don't know if you could wait for her, but that is what she told me and she wanted to convey to the court.
No, don't hang up. Don't hang up.
I can allow him to return to the location with a police officer to verify that she does not live there. And if she doesn't live there, then he may return to the location. But until I hear something from Miss Garrison, I'm afraid it's going to be no contact.
Mr. Garrison, do you want to go ahead and move forward with that?
Yes, sir.
Okay. Yes, Judge, that's okay.
Mr. Garrett, and so Miss Pope, do you have any objection that he has to stay away from the location, but I'm going to allow him a one-time visit to verify that no one lives there? And if Miss Garrison does not live there, then he can be permitted to return to that location.
State has no objection.
Okay. Mr. Garrison, and do you stipulate to the factual basis, venue, and ID, Mr. Finley?
I do, Judge, and just correct, so it's just his mom, or I'm sorry, his brother and nephew both live there, just for the record. I just see them,
All right. As long as Carolyn doesn't live there, that's the only issue. She's not present on Zoom. I have no way to verify that she wants contact or otherwise.
Understood, Judge. Can anything be done I guess, after court, if she does?
If she shows up, I can always modify the sentence from today.
Understood, Judge.
Okay. So in the meantime, Mr. Garrison, have you consumed any medicine or alcohol recently?
No.
And have you understood your attorney's explanation in the proceedings so far?
Yes.
And are you satisfied with your attorney services?
Yes, ma'am.
Is anyone forcing you to enter a plea of guilty today? Are you doing so freely, willingly, and knowingly? And do you understand that if you plead guilty today, you would have to give up your constitutional right to a trial in front of a judge or a jury, to give up your right to confront your accuser, challenge the evidence and the witnesses brought against you, have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery and one count of cruelty in the third degree?
Guilty.
Your sentence is 12 months to serve 44 days, credit for time served 22 days. If you have no other holds at the jail, you will be released within 24 hours. You must report to probation next Thursday before 3 p.m. That's December 28th. Do you understand, sir?
Yes, ma'am.
Probation is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 12 anger management classes. You must begin those classes within 30 days of being released. You're also to complete 40 hours of community service at any nonprofit agency that's not a church and not a school. Presently, you are to have no contact with Carolyn Garrison, which means you have to stay 200 yards away from her and do not communicate with her in any way, form, or manner. You're also to stay away from the home. I don't have an address.
Sorry, well, it was 7618 McGilty, McGillc UTY Drive.
Is that in Atlanta?
Atlanta, yes.
Okay. Well, presently, you're to stay away from 7618 McGillty Drive. I'm probably butchering that name, in Atlanta, Georgia. You can return to that location one time with a police officer. If the police officer confers with the other members of the household that Carolyn Garrison does not live there, then you can return to that location. Do you understand?
Yes, ma'am.
Don't forget to report to probation next week. Thank you.
Okay, thank you.
Judge, I have a quick announcement for Mr. Beavers. I was told that there needs to be a breakout for Mr. Beavers.
That's what Ms. Abden wants, yes.
Yes.
Your Honor, on that last case, it should be Union City, not Atlanta, but it's 7618 McGilty Drive, Union City, Georgia.
All
For the
right.
stay over. Thank you.
And Ms. Strong on the count 2 is 12 months probation concurrent with count 1. Thank you.
Judge Law, can we get that set up or the breakout for Ms. Abden, Mr. Beavers?
Where are you going to locate Mr. Beavers?
No, Ms. Abden wants to do a breakout, not, right, Beavers is not included. It's just, go ahead, Ms. Abden.
Ms. Abden, I'm really confused what y'all want.
Your Honor, so sorry for the confusion. So Mr. Beavers was on our competency calendar. He was reset to this calendar. I would like to discuss the state's recommendation as it relates to the MHET that they are still recommending.
Okay. So in that case, Ms. Abden, you'll need to get on your laptop. And then I will address that when I'm addressing my 11 o'clock cases.
Sounds good. Thank you, Your Honor.
All right, thank you. And Mr. Beavers does not need to be in the breakout.
No.
All right, thank you.
We're gonna do number 31, Mr. Thornton.
Is that the gentleman in courtroom 2 or jail court iPhone?
Courtroom 2.
Courtroom 2. Mr. Thornton, can you raise your right hand, please? Okay, good. I just want to be sure.
And Judge, I wasn't given, so there wasn't a plea offer on the, so I just, we could hear. Ms. Pope, if you don't mind, what was the offer?
12 months to serve, credit for 16 days from 12/6/2023.
Okay, so it's time served.
No, 12 months to serve. He would get the credit for the time that he served, but it's 12 months to serve.
Okay. Yes, Judge, this is.
Oh, mute your screen, Mr. Finley. Mute your screen. If you're talking to your client, please mute your screen.
No way.
Always.
That's
I have announcement. Position number one, Mr. Bethel Tedeschi, it went downtown court. He's transported to downtown court.
Debeski Barth is downtown?
Yes, that's what it says on the pull sheet.
Okay, we'll reset that to December 28th. Thank you.
Did you need this muted so you can talk to him?
Position number 11 and 12, Upshaw, she needs to be in the breakout room.
Okay, who was the client, Mr.? So Mr. Finling is the client, and we'll handle that in a breakout session with the 11 o'clock cases. Mr. Finling, how are we proceeding with Mr. Thornton?
No, am I unmuted?
No, you're not muted.
Okay.
I can hear you.
Okay, yes, Judge, I just wanted to briefly speak with him just for a second, and then I am on my laptop now, so I can talk to Ms. Upshaw very briefly as well. Both of those should be, very quick, but I just need to briefly speak with them.
All right, you'll need to let the host know when you're ready to speak with Ms. Upshaw.
Okay, will do, Judge.
And I just want to make sure that that everyone understands the state's recommendation. It is 12 months to serve, not commuted to the time you serve, but I'm okay. I just want to make sure that was understood.
Yes, understood, Pope, Ms. Pope. Thank you.
Mr. McLean, did you have a case to address?
ACDC wants me to get in contact with them. Our two phones are in use. At ACDC, I only had Corday, Cato, and Kane, so I imagine since it's probably only about the 11 o'clock matter on this Corday. I'm guessing.
Okay.
Who has 18, Mr. Floyd?
18?
Yes.
That would be your client, Mr. McLean?
Floyd is, yes.
Okay.
Can we put him next?
Very good. David Floyd is 23 CR 7808G. He is appearing on jail court iPhone. If you could put your hand down from your face, Mr. Floyd. Thank you. Mr. Floyd is charged with battery and theft by taking from December 8th, 2023. Mr. Floyd, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Do you see Mr. Michael McLean on the screen? Mr. Floyd? Oops, we lost. Please unmute jail court iPhone. Okay. All right, Mr. McLean, is that your client?
Yes, Your Honor. He is pleading not guilty today. We waive formal reading of the accusation. He has a bond request.
Okay. Mr. Floyd, as your attorney has announced, you are planning to enter a not guilty plea to the misdemeanor offenses of battery and theft by taking. Upon such an entry, your case will be scheduled for trial, where the prosecution would have the complete burden to prove the charges against you beyond a reasonable doubt. If the prosecution does prevail and overcome your legal presumption of innocence, you could be convicted of one or more of these offenses and face a penalty of up to 1 year in jail and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Yes.
You plead guilty or not guilty?
Yes.
Okay, that is a change of mind, Your Honor, which sometimes does happen. That's fine. Let's see, the state's recommendation is, well, the state can read its recommendation. We know what it is and what we've discussed. So if that is a negotiated plea as opposed to a non-negotiated plea, I understand what's up. Mr. Floyd, were you planning on accepting the recommendation of the state to make it a negotiated plea? Or were you thinking you would do a non-negotiated plea in which you would put forth your own opinion?
So just go.
Mr. Floyd, did you understand your lawyer's question?
I think we probably ought to have a private conversation, Your Honor. So if I may get on a breakout with him.
That's fine. I can also reset the case to next Thursday because I will have no prejudice to the proposed offer.
That is true.
All right, but we've lost him. Jail court iPhone dropped off the Zoom.
Well, there they are.
Okay. Deputy Francois, who do we have now?
Going back.
No, we're back. We're still here, Judge. We're here.
Jail court, okay, where's jail court iPhone? Are you on a different screen? Okay, there he is. Mr. McLean?
Are y'all on 4 South?
Yeah.
Okay.
Mr. Floyd,
Yes.
could you come closer to the phone, please? Okay. Now, did you speak to your attorney yesterday?
Yes.
And did your attorney and you discuss the plea offer from the prosecution?
Yes, I said I want to plead guilty.
So have you changed your mind because your attorney thought you were going to plead not guilty and have a trial?
No, ma'am, guilty.
Okay, so Mr. McLean, your attorney will need to speak to you to go over the terms of the plea offer.
I can simply take about 10 minutes and run up to 4 South and just come back into this courtroom.
It's entirely up to you, Mr. McLean, but we have 11 o'clock calendar, which we started 30 minutes ago.
Yeah, but they're not my clients except from here.
All right. I think it's best, Mr. McLean, if you wait till one of the laptops is available.
Okay.
Well, I'm gonna go over to the north side then, because I'm doing this by myself and I need to take a 27.
Okay, give me a minute. Miss Rachel Abden, is your laptop available?
Yes, Judge.
Mr. McLean, why don't you use Miss Abden's laptop?
That's probably faster than turning on my Zoom. Yes, Your Honor, that'd be fine.
Okay, and sorry, Judge, Mr. Finley asked to be put in the breakout room with Ms. Upshaw. Where is she located?
She's at ACDC.
DC. Okay, I just want to double check. Okay.
All right.
And so am I putting Mr. Finley in one as well?
You're putting
Mr. McLean.
you're putting Mr. McLean, who is going to use Rachel Abden's laptop.
Mm-hmm.
Mr. McLean, Miss Abden's waiting for you, please.
And who's he going in with?
He's going in with jail court iPhone.
Okay, thank you.
Your Honor, Deputy Francois has a request. I have a client here named Mr. Thomas. It's a non-negotiated plea. If we were to do that now, that would improve flow of people through the courtroom doorways.
All right, jail court iPhone, could you hold for 3 minutes? Thank you. All right, Francois, Thomas is ready?
This is an add-on, Mr. Thomas, number 6.
Okay. Amir Brandon Thomas, case number 20 COV 0000384, is accused of simple battery with regards to a peace officer and obstruction of a law enforcement officer from September 1st, 2020. He also has position 4, 21 CR 006149E, in which he was accused of harassing communication from March 15, 2020. Third case is position 5, which is a bench warrant 23 FTA 1133, in which he had a failure to appear on November 1st, 2023. And the fourth case is 23 FTA 1134, again, a bench warrant. So with regard to these 4 cases, Mr. Thomas, you've been advised to be a right to remain silent, and your attorney is Mr. McLean. This is going to be a negotiated plea,
Non-negotiated plea.
Oh, non-negotiated plea. All right, Mr. Thomas, please raise your right hand. Do you solemnly swear and affirm the testimony we provide you that you've provided?
Yes, ma'am.
Do you be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. This is a non-negotiated plea, which means that the prosecution is going to give a recommendation and that your attorney is going to give a recommendation, keeping in mind that I have to either select one of those recommendations or have the case scheduled for trial. Ms. Pope?
Yes, on position, well, it was position 29 last time. The recommendation is 12 months, served 90 days, credit for 18 days served from 5/19/2022 to 5/22/2022 and 12/6/2023 to present. 6-week anger management course. Count 2, 12 months concurrent to count 1 and a $300 fine. On the second case, it was 12 months probation. 40-hour credit for the time that he served. 40 hours community service, no further contact with Kalisha Corley, concurrent with case number 20 COV 000384. It's a global recommendation.
All right. And what is the reason for this recommendation? Why is the additional time being sought?
There's a 2022, a recent arrest for criminal damage to property in the 2nd degree, simple battery against a police officer, cruelty in the 3rd, obstruction of an officer, felony and a battery. There was also, let me pull this and make sure, because I believe this is a prior recommendation that the state stands by.
Stand at the door. I'm gonna put you in.
Anything else?
No, Your Honor.
All right.
At this time.
Mr. McLean?
Your Honor, the only issue for him is the additional jail time. He would love to be out much earlier, possibly even would ask the court to consider time served on the jail portion of the sentence, even if the court felt that making the point about the purposes of punishment by increasing the community service, increasing the fine, increasing the probation total time, any of those things would be preferable to staying here any longer for him. I note that his birthday's in the summer. So this summer it was 1998. So he turned, let's see, 25. And these cases are from 2020. And not everybody has a smooth line in the maturation process or the development or evolution, if you will, of one's character and one's personality. Sometimes it's more like what biologists, I think, refer to as punctuated equilibrium rather than a smooth curve. So what he's saying is that recently he has been thinking and introspecting, and he has made a commitment to himself and to society. And it's also partly a religious commitment to completely walk away from his previous lifestyle and modes of behavior. He is not making any excuse for the allegations against the police officer Davis in 2020. He recognizes that behavior as inexcusable and unexplainable. He feels he has matured more in the last 3 years. He has gotten in trouble in the last 3 years, but he has now been in continuous custody since October 26th. And he feels that if the court could let him out now, even if it increases it to 24 months probation, even if it adds to community service and the fine, that he would beg the court to have mercy on him in that fashion.
Anything else, Ms. Pope?
No, Your Honor, but let me make sure. I think he's being held on those. Is he being held on the other?
He's got the
charges?
$3,000 bond on the bench warrant, but I don't know about this other 2022 arrest. It's not in Fulton County.
Okay.
Unless you have information otherwise.
He says he is bonded out from the DeKalb matter and will go to it.
Okay. Nothing further.
All right. The court will, I noticed that he has accrued 23 days in Fulton County Jail, and I'll give him credit for 23 days. It would be 12 months to serve 50 days, credit for time served 23 days. So he would have another 2 days to serve at the Fulton County Jail. Once he completes that, he will be reporting to probation and to complete the terms of the probation, including the 6 anger management classes. I'm going to require him to do 40 hours of community service. Oh, that's already required. So yeah, that's already required on position 4. And as well as the anger management classes and the $300 fine. Is that something that your client would like to consider?
Very much so, Your Honor, yes. No, we're talking about-
Yes, no?
Yes, Your Honor.
Okay. Mr. McLean, do you stipulate to the factual basis, venue, and ID for these two cases?
We do.
For Mr. Thomas, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And do you understand that, I mean, are you satisfied with your attorney?
Yes, ma'am.
And okay. And is anyone forcing you to plead guilty today?
No, ma'am.
Are you doing so freely, willingly, and knowingly?
Yes, ma'am.
And do you understand that if you decide to plead guilty, you will be giving up your right to go back to court and have a trial, to be able to confront your accuser, challenge the evidence brought against you, present any defenses or mitigating factors if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am. Yes, sir.
On case number 20 COB 000384, charge of simple battery against a peace officer and obstruction of a law enforcement officer, how do you plead?
Yes.
Your sentence is going to be 12 months to serve 50 days, credit for time served 23 days. After you've served the additional 2 days at the jail, you will report to probation next Thursday before 3 p.m. While on probation, you will complete 6 weeks of anger management classes. Count 2 with regards to obstruction is going to be 12 months probation concurrent with count 1, and you have an additional $300 fine to pay. With regards to position number 4, 21 CR 6149E, how do you plead to one misdemeanor charge of harassing communications?
Guilty.
Your sentence is 12 months probation. You will report to probation, and while on probation, you will complete 40 hours of voluntary community service at any nonprofit agency that is not a church and not a school. While on active probation, you are to have no contact with Kalisa Corley, which means you cannot speak to her in person, not on a phone, not on a computer, and definitely not through social media, and also to stay 200 yards away from her. The 2 bench warrant cases shall be null pros. Thank you.
Question for me.
Mr. McLean, if you can get to Miss Abdon's laptop, jail court iPhone is waiting to be in a breakout with you.
Yes.
Judge, I just got a quick announcement. Per my captain, she's requesting for ACDC to complete all their people. I'm just trying to figure out what's going on with ACDC.
Mr. Finling wanted to speak to Miss Upshaw. Are we ready to proceed, Mr. Finling?
Yes, Judge. I spoke with Ms. Upshaw and Mr. Thornton, so I'm ready to go on both those.
All right. This is a probation revocation matter with regards to Crystal Upshaw, and she is located at the ACDC location. Ms. Crystal Upshaw, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finling. This is a probation revocation matter in which you were convicted of simple battery in 18 CR 1728Y, and the probation violation case is 23 PV 1711. Officer Allison, you're under oath. What's the reason for the revocation?
Ms. Upshaw, she failed to complete anger management and did not report to a prior hearing on June 22nd, 2023. She has 122 days remaining. Probation is recommended to continue on probation and enroll in anger management within 30 days.
How many more classes does she have?
8 weeks.
8 classes, okay. Mr. Finley?
Yes, Judge. I did speak with Ms. Upshaw. She does understand that, and she assured me that she would enroll in classes within 30 days, like is asked. So,
Ms. Upshaw, do you recognize that you have not completed your anger management classes for your sentence?
no.
Ms. Upshaw, you need to answer my question before I can proceed. Do you understand that you need to do 8 anger management classes in order to satisfy your sentence?
Yes,
And you understand that you'll be reporting to probation every month and to complete your anger management classes?
yes,
And do you understand what would happen if you don't do the anger management classes?
yes.
What will happen?
I'll come to jail.
What?
I'll come to jail.
So what are you going to do next?
My anger management class.
Next thing you're going to do is report to probation next Thursday before 3 p.m. at 132 Mitchell Street. Do you understand?
Yes,
And you will report every month for the next 122 days. You need to answer yes or no, so I'll know that you understand what I'm saying.
yes,
And you will have to enroll and complete 8 classes for anger management. They are once a week. Do you understand?
yes,
So that means as soon as you report to probation, you must enroll in those classes and start those classes right away.
yes,
So probation, by her second visit, she must have already completed 1 class.
Okay.
Do you understand, Ms. Upshaw?
yes,
Given the time frame, you don't have much time left to complete the classes. So by your second visit, you must have completed 1 class at least. Do you understand?
yes,
This is a probation violation. She will continue on probation, report next Thursday before 3 p.m. and complete the 8 anger management classes. By the second report date, she must have completed at least 1 class. Thank you.
You got it?
Thank you, Judge.
All right, Deputy Francois, Captain, we concluded with ACDC. Thank you so much. Courtroom 2, Deputy Francois, do we have any other cases on the probation revocation and SAP?
Yeah, we still have a lot of people who need to be done. Okay, number 23, Griffin. Come on, Mr. Griffin.
And Judge, this was notated as a bond hearing as well, but this is just going to be an arraignment, please.
Mr. Griffin is what position on the SAP calendar, please?
Number 23.
Okay. Francois, what are we doing with Marcavius Boulay and Colin Reynolds for probation revocation? Sorry, for all purpose. Are we going to get to hear them?
Who, repeat that again, Judge?
Marcavius Boulay and Colin Reynolds, they were reset from Tuesday.
Boulay, that's on 4 North. So I have Ms. Blunt doing that on the floors. Who else?
Okay. And then I have a add-on on probation revocation, Antonio Snelling.
Yeah, Snelling, I don't even see his name. But all the other cases, what we don't have here, they're gonna be done from the floor with Ms. Blunt.
Okay. Is this Sanchez Griffin? Mr. Finley?
Yes, that's correct, Judge.
Position 23 is 23CR4806F. Mr. Sanchez Griffin is charged with battery family violence from August 4th, 2023. Mr. Griffin, you've been advised of your right to remain silent, and your attorney is Mr. Finley. I understand that you will be entering a not guilty plea. And Mr. Finley, just to reiterate, you are waiving your right, the reading of the accusation.
That's correct, Judge.
Okay, Mr. Sanchez, upon your entry of a not guilty plea to the battery family violence charge, the case will be scheduled for trial. At the time of the trial, the prosecution has the complete burden to prove the charge against you beyond a reasonable doubt and to overcome your legal presumption of innocence. If the prosecution does succeed, you could be convicted of the offense and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Your case is arraigned and further notice for trial. With regards to your current case, you do have a bond. And I'm just waiting for that screen to pop up.
He does.
Yeah, I think part of the, if I might, he was actually recently arrested on a separate simple battery case, 23 CR 007768F. And I believe it was that case that he that put him on this calendar. If I'm not mistaken, however, it did not appear on the calendar.
She's correct.
He was seen on
That's what I'm seeing.
okay.
All right. So Mr. Finling, it appears that it's another case, and I don't know when that other case is going to be. Is it scheduled for today?
It was supposed to be scheduled for today, but it wasn't placed on the calendar. So if he would have taken a plea, would have handled both cases together.
All right. Mr. Finley, what would, it looks like is the new case that's holding him in jail, not this case. Is that the one you wanted to address?
Yeah, Judge, I mean, I just wanted him to get arraigned on both. I know he does have a bond on both.
Okay, 007768F. So he's already been arraigned on the case ending in 4806F. In the second case is 23 CR 007768F. He's accused of simple battery, family violence, and criminal trespass from September 2nd, 2023. He had his initial appearance on December 7th, 2023. And the case was supposed to be further noticed 2 weeks out. So here we are. And with regards to this new case, do you waive a reading of the accusation?
Yes, I do.
And Mr. Griffin, upon your entry of a not guilty plea to these two new additional charges, this new case will also be scheduled for trial. At the time of the trial, the prosecution still has the same burden to prove these new charges against you beyond a reasonable doubt, and if they do prevail, you could be convicted of these two new charges as well. Penalty for such a conviction would be up to a year in jail and or up to $1,000 fine. So unfortunately, Mr. Finlay, I was the one who did the bond in this new case as well. And I expressly noted that this has been Mr. Griffin's repeated violations with the same victim. And in fact, this new case appears to be a violation of the no contact bond order in the 4806F. So why am I reconsidering this bond?
Oh, no, Judge, I'm not sure if I mentioned earlier when we first started that I did not want to address bond. I did not.
Oh, you did not? Oh, I'm so sorry. I'm sorry, the audio is not very good.
For the reasons you just said is exactly why I was not going to address bond.
All right, I apologize. I thought I heard you say otherwise. All right, so both these cases are arraigned and they'll be scheduled for trial. Thank you.
Thank you.
Position number 18.
Floyd is ready.
I'm sorry, Mr. McLean, what did you say?
Floyd is ready. That is a negotiated plea.
Okay, to this faster, be really helpful. Remind me, which calendar was that on? Because I've got 4 calendars in front of me.
Position 18.
SAP 18. Okay, thank you.
Yeah.
My last person.
All right. Mr. Floyd has been advised of his rights and apparently changed his mind about his plea, so now he wants to proceed with the plea hearing. Mr. McLean?
Yes, Your Honor.
Okay. Mr. Floyd, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am. Yes.
Thank you. Mr. Findling, did I get a not guilty allocution from Mr. Griffin on the second case?
I believe he was arraigned on both, Judge.
Okay, did he say not guilty on the second case?
I'm not sure. You want me to pull up?
Just bring him up again. For some reason, I got this niggling doubt in my head that he didn't allocute not guilty.
Mr. Griffin, really quick.
I thought you guys were on jail court action.
No, Francois, it's my mistake. Mr. Sanchez, Mr. Griffins, on the second new case in which you are charged with simple battery and criminal trespass, how did you plead?
Not guilty.
All right, thank you. I'm now satisfied. Thank you. Back to Floyd. Sorry about that. Mr. Floyd, Ms. Pope, what's the recommendation for Mr. Floyd, who is charged with battery and theft by taking?
Yes, Your Honor. On count 1, 12 months probation, serve 120 days credit for time served since December 9th, 2023, balance probated. FVIP, 40 hours community service, no further contact with Jason Roberts. Stay away from 1870 Myrtle Drive, Southwest. Count 2, 12 months probation, restitution to Jason Roberts, open for 30 days, no further contact with Jason Roberts, stay away from the 1870 Myrtle Drive, Southwest, concurrent with count 1.
John Davis.
All right. And no information or restitution at the present time?
I don't have it. No, Your Honor.
Okay.
Your Honor, this will result in 47 extra days from today.
Looks like it.
John Davis.
He understands the 48 hours, 40 hours, and he understands the FVIP.
All right. This is non-negotiated, so.
No, Your Honor, it is negotiated.
Okay.
And all the obligations.
All right. Do you stipulate to the factual basis, venue, and ID, Mr. McLean?
We do so stipulate.
Thank you. Mr. Floyd, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes.
And is anyone forcing you to enter a guilty plea today?
No, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
Well, do you know that if you enter this guilty plea that you won't have a trial? You will not go back to court. You will not confront your accuser. You will not get to challenge the evidence brought against you or present any defenses. And you will not be able to have the state trying to prove the charges against you beyond a reasonable doubt. Did you know that?
Yes, ma'am.
And are you willing to give up your rights?
Yes, ma'am.
How do you plead to 1 count of battery and 1 count of theft by taking?
Yeah, guilty.
Your sentence for the battery is 12 months to serve 120 days, credit for time served 13 days. You have about 47 more days to serve at the Fulton County Jail. After you've been released, you must report to probation at 132 Mitchell Street and the immediate next business day, which can be a Monday, a Tuesday, or a Thursday. Probation is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will report every month. You will enroll in a domestic violence intervention program within 60 days of being released. You will also complete 40 hours of community service with any nonprofit agency that is not a church and not a school. For the theft by taking, same sentence, 12 months probation. The case will be held open for 30 days for the prosecution to schedule a restitution hearing in order to determine the damages that you owe to the victim. At all times while you're on probation, you're to have no contact with Jason Roberts, and stay away from 1870 Myrtle Drive in Southwest Atlanta. Do you understand, sir?
Yes, ma'am.
That concludes our plea. Thank you. All right, courtroom 2, are we concluded with SAP?
No, we still have more. We're gonna go to, number 2, Mr. Beavers, and a breakout is not needed. Come on, Mr.
I have reiterated, Mr. Beaver's, right to remain silent and with regards to his 2 cases. Mr. Beaver's cases are positions 2 and 3, 23 CR 7236Y, charged with criminal trespass, and position 23 CR 7465Y, he's charged with trespass and disorderly conduct. And this all appears to stem from the Whole Food store at 77 West Paces Ferry Road in Northwest Atlanta. Mr. Beavers, your attorney is Ms. Abdon, and we're going to have a plea hearing. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Mr. Pierre Thomas, what is the offer for both these cases?
Your Honor, the recommendation from the state on the case ending in 7236Y, criminal trespass, is 12 for the defendant to serve 12 months on probation, to serve 4 days in custody, credit for the 2 days that he's already served. Looks like from November 21st, 2023 to November 22nd, 2023, for the balance to be probated, for him to stay away from the Whole Foods located at 77 West Paces Ferry Road, Northwest in Atlanta, Georgia. And Your Honor, the recommendation for the case ending in 7465Y, on count 1 criminal trespass, it is 12 months probation for the defendant to serve 48 days, credit for the 24 days that he's already served. Looks like he was booked in on November 28, 2023, for the balance to be probated, for him to complete 6 anger management courses, for him to stay away from the Whole Foods again, which is located at 77 West Paces Ferry Road, Northwest in Atlanta, Georgia. And as it relates to count 2, disorderly conduct, for the defendant to serve 12 months on probation, to have no further contact with Natasha Lawrence, and that is to be concurrent with count 1. And the case as a whole is to be concurrent with 23 CR 0072336Y. This is a global recommendation. Our office has not been able to get in contact with Ms. Lawrence, so if we can sound from Ms. Lawrence at the conclusion, that'd be greatly appreciated. But there is nothing further to add from the state at this time, Your Honor.
And the state is dropping the MHET requirement?
Yes, Your Honor, I did not mention
Okay.
it in the recommendation.
Thank you. Natasha Lawrence? All right, Ms. Abdul?
Your Honor, we're ready to proceed. I'm just requesting that you consider waiving his probation fees due to his indigency, and the fact that he needs to pay for those anger management classes.
I can waive his probation fees for the first 3 months, which would be January, February, up to March 31st, 2024. But after that, he'll need to continue reporting and start paying probation fees.
Thank you, Your Honor.
Do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
All right. Mr. Beavers, with respect to these 2 cases involving the Whole Food store, first of all, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am. I'd just like to know when would I be, told to start recording?
I don't understand what you just said.
He asked when he would need to start reporting to probation, Your Honor, and I could talk to him about that.
I will tell you that very soon. But right now, I want to make sure that you are pleading guilty freely, willingly, and voluntarily. Are you satisfied with your attorney services?
Yes, ma'am.
Is anyone forcing you to take this plea? In other words, are you just taking this plea to get out of jail?
The one is Courtroom email.
And are you entering this plea freely and willingly?
Yes, ma'am.
Do you understand that if you enter this plea, that you will not get a chance for a trial? You will not go back to court to face a judge or a jury. You will not be able to confront your accuser, challenge the evidence that could be brought against you, and have the prosecution try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And you understand that this will be the final decision of the court. There is no right to appeal.
Yes, ma'am.
How do you plead to criminal trespass on November 20th, 2023?
Guilty.
Your sentence is 12 months to serve 4 days, credit for time served 2 days, and you are to stay away from the Whole Food store at 77 West Paces Ferry Road. Stay 200 yards away, which means the length of 2 football fields. How do you plead to criminal trespass and disorderly conduct on November 27, 2023?
Guilty.
Your sentence is 12 months to serve 48 days, credit for time served 24 days, balance probated. If you have no other holds, you will report to probation next Thursday, December 28th, 2023, before 3 p.m. Probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you are to complete 6 anger management classes, and you must begin those classes within 30 days of being released. I will waive your probation fees for up to and including March 31st, 2024. You will continue to report to probation and start paying probation fees from April 1st, 2024 onwards. At all times, you are to stay away from the Whole Food store that I've just mentioned, and you're to have no contact with Natasha Lawrence. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. Thank you.
Judge. Add on position number 1, Boulay.
I'm gonna write all that stuff down for you and give it to you.
Yes.
Mr. Pierre Thomas, on position 2, Mr. Beavers, was that a balance suspended for 4 days to serve 2 days, balance suspended and stay away from Whole Foods?
I think I have it on my notes as balance probated, but I will double check, Your Honor.
Position 1 on the add-on all-purpose calendar, is that Mr. Marcavius Boulay?
Yes, ma'am.
All right. Mr. Marcavius Boulay, you are charged with battery in 23 CR 7736Y. Mr. Boulay, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean, what are we doing, sir?
I need to speak with Mr. Boulay to find out his intention today. He previously spoke with other public defenders, and I need to catch up to speed with him and he with me.
Well, you may have to come up here because this phone is about to go dead. I'm sorry, the battery is low on this cell phone.
All right, and that's 4 South, right?
I don't have no charge.
And Your Honor, I do have a Mr. Brewer who's still here in the, Larry Brewer is still here in the courtroom too.
Well, you need to go on a laptop to go into a breakout, and or you need to go speak to jail court iPhone, since you would need to charge your phone. Do you have another case, jail court iPhone, at that location?
I have 3 people waiting.
All right, let's hold off on Mr. Boulay. Next one is Colleen Reynolds. Do you have a Colleen Reynolds?
No, but I have position number 34, Mr. Woke.
Position 34. All right, Mr. Reynolds, please hold. Position 34. Since we have a yeah, I'm waiting on Mr. Thomas to tell me that. Okay. This is David Justin Wolk, position 23 CR 7799C, accused of criminal trespass and willful obstruction of an officer from December 7th, 2023. Mr. Wolf, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. Your attorney is going to be Mr. Zach Finling. Mr. Finling, this is going to be a non-negotiated plea for your client, Mr. David Wolf.
Your Honor, the state would like to amend its offer and it may make it a negotiated plea. It should have been 30 days as opposed to 60 days. Credit for the 15 days.
All right, so in that announcement, Mr. Finling, would this be a negotiated plea?
It sure would, Judge. Yes.
All right, Mr. Wolf, please raise your right hand. Mr. Wolf, do you solemnly swear and affirm the testimony provided will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. And so, Ms. Pope, so it's 12 months to serve 30 days, credit for time served 15 days. Anything else?
Yes, the remainder was the same. Stay away from 744 Law Street Northwest and no further contact with Ayanna Burton. Count 2 is 12 months probation concurrent to count 1.
And so he'll be on probation?
Yeah, it was 12 months probate. I'm sorry, it should have been balanced probate. The only thing the state was amending was the 60 days to 30 days.
Okay.
Everything else would remain the same.
Mr. Finling, does your client accept these terms and do you stipulate to the factual basis, venue, and ID?
Yes, Judge, we do agree to the change to it being time served. I am, I guess, a little bit curious or confused now that we're talking about why it is balance probated since there's only a stay away. I guess.
And no further contact.
And no further contact. I mean, I would like that to terminate at some point if he is going to be on probation.
I'll require him to report for the months of December, January, and February.
Okay, so it's.
And then after that, his probation will be non-reporting.
Your Honor, may we be heard?
Sure.
Okay.
The state's concerned with this one, it wasn't just a criminal trespass where he was on the outside. He actually entered the home of Miss Ayanna Burton. She does not know who he is, and he made himself comfortable. So there was a little bit more concern, which is why the state did not ask that it just be credit for time served.
I may be, was it an occupied home or was it one of those vacant homes?
But there was no indication that he was attempting to steal, but he did enter onto the property, and I can tell you if it's occupied or vacant. Give me 1 moment.
Okay.
But yes, Judge, we do agree, and I agree to and appreciate that he can be non-reporting after a period of time. And just so Mr. Wolk understands, because we talked about the possibility of him serving 15 days. Mr. Wolk, you're not going to be serving 15 more days. They are allowing it to be essentially a time served, so you should be processed out hopefully sometime in the next 24 hours.
Thank you. Thank you.
Let me see what phone she wants.
And Mr. Wolk, what's a good phone number for you?
I don't have access to a phone number.
Okay,
Unless
so
I want to you as
right,
soon as I
right. So you didn't have an address. Okay, so just make
Ms.
sure
Pope, anything else?
that you get in contact with probation.
I didn't have any indication that it was a vacant home. I was trying to pull it to make sure, but that was not anything that was listed. So
Only thing I have is there's a broken window. So
there's a abandoned property.
well, that he entered the home through
No,
a window
that's-
without
that-
the
no.
owner's consent.
it's not abandoned.
Oh, I'm sorry. I am so sorry.
Good. Okay. Anything else, Ms. Pope?
Nothing further, Your Honor.
All right. Mr. Finling, I will amend it to non-reporting probation as of March 1st, 2024, provided that he doesn't get arrested and he doesn't violate any of the conditions of the bond, I mean, of the sentence. So, Mr. Wolk, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Even though we are evicting people in Africa, I am completely satisfied with my attorney.
Just have a seat.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am. He made it
And
100% clear to me.
And do you understand that by entering such a plea that you'll be giving up your right to go back to court to challenge these charges in a court of law in front of a judge or a jury?
My attorney made it 100% clear to me.
All right, so you will not be able to confront your accuser and have the state trying to prove the charges against you beyond a reasonable doubt. You're prepared to waive all these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass and one count of willful obstruction of an officer?
Guilty.
On the trespass, your sentence is 12 months probation to serve 30 days, credit for time served 15 days. You'll report to probation next Thursday before 3 p.m. at 132 Mitchell Street.
Okay.
While you're on probation, you are to stay away from 744 Law Street and have no contact with Ayanna Burton. Staying away from that location means staying 200 yards away. That's a distance of 2 football fields. Understood?
Yes, ma'am.
Count 2 on obstruction is going to be 12 months probation concurrent to count 1. If you comply with the conditions of the bond and you don't get arrested again, your probation will be non-reporting from March 1st, 2024 onwards. However, non-reporting means that you're still required to stay away and have no contact.
Okay. Thank you.
Thank you.
Yes, ma'am.
Can I have Mr. Snelling? He's an add-on as well. I'm not sure the position number.
Mr. Snelling is add-on for probation.
Allison sounds thrilled when she's finding.
And Your Honor, I don't know if you still needed the answer, but it was balanced probated on both cases.
Okay, does that answer the question, Ms. Strong? Okay. This is Antonio Snelling at Jail Court iPhone. He's got a probation revocation matter under 22 CR 5264Y, in which he was convicted of battery, family violence from August 6, 2022. The probation revocation matter is referred to as 23 PB 1697. Mr. Snelling, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean.
Your Honor, I hate to interrupt. Mr. Snelling was on I believe it was the last week's probation calendar, and what is the probation office's recommendation?
Oh, yeah.
He was on for Tuesday. It'll be the same that it was sent from Tuesday.
Could you give me the recommendation?
Nothing has changed. Yes. Mr. Snelling, he owes probation supervision fees in a total of $160, victim crime funds in a total of $36. He did not report as directed on June 20th, 2023. He did not complete 12 weeks of anger management and did not complete 40 hours of community service. He has 46 days remaining. Probation is recommended to revoke and receive the time credit for that he was in custody on this warrant, which would be 17 days.
So revoke probation, serve 46 days, credit time 17 days. That's the recommendation.
Yes.
Mr. McLean? Yes, sir.
So the resulting number of days in jail would be how many?
It'll be 46.
He'll be at 29 days.
With the 2 for 1, it'll be 14 days.
Right. If they're doing 2 for 1.
If they're doing 2 for 1, it'll be 14 more. Yes.
Right. And we were going to note to the court that it's hardly possible, even if we were to ask to continue on probation, there's just not enough time to get those classes done. And he's thrown himself on the mercy of the court and asked for as little time as possible.
And I think jail court's iPhone battery power just finally lapsed.
Oh, I finally got on Zoom. Okay. I'll run up to 4.
Judge, can we do courtroom 2? This is going to be Colin Reynolds on add-on number 2.
All right. Officer Allison, hang in there. You're almost done.
I'm still here.
Thank you.
So, Your Honor, our only point on the revocation was that he does have a short number of days, and being the holiday season,
I understand, Mr. McLean. I don't mean to interrupt, but I need him on the screen before you can address his case.
where to go?
Okay, let's go to the young man next to you, Colin Reynolds.
Your Honor, it appears that Colin Reynolds has an attorney whose name was Ben Shaddah. And we believe that that person is a conflict attorney, probably. That was the person we were trying to get hold of by phone. He was at some court, like Cobb County Superior Court on Tuesday, I believe it was, or last Thursday, one of those two. So it's because he has co-defendants that I think that probably Mr. Ben Shaddah was probably a C3. He's probably appointed to be conflict attorney. We hated the idea that the lack of an attorney would make Mr. Reynolds miss out on a time served as the jail portion of the sentence, possibility of a plea. So we sure didn't want him to see.
I'm sorry, Mr. McLean, you're gonna have to speak up. The background noise is drowning out your announcement. Okay, so we cannot reach his attorney. We had reset the case. The attorney is Mr. Shida. He's not present. What are you asking, sir? I need to appoint another conflict counsel for him. That I do know. What else are you seeking?
If it could possibly be done today, is Miss Maureen McLeod available by phone? Is Dennis Murphy available by phone? Is Watson Cafe available by phone?
I won't find out till I start my competency calendar to see if any of them show up. Otherwise, he's got to be reset to December 28th to confer with conflict counsel.
I'd rather see him go pro se than do that, Your Honor, and he is a combat person. So let's try to get hold of those folks, and I would encourage him to probably try to stay on the calendar today.
This is state all-purpose add-on position number 2, which was reset from Tuesday. We still don't have, and this is charged with carrying a weapon without a valid license, a first offense. He's what, 18 years old? No, he's 20 years old. Isn't that correct?
Yes, ma'am.
All right, and Mr. Reynolds, just remember you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and unfortunately, whoever was appointed last for you has not shown up second time in a row. So we're going to retain counsel to represent you. Presently, you do have another open case in which you've got a $38,000 bond. Mr. Is that bond holding you at jail?
Yes, ma'am.
Okay, so we're going to reset your case to December 28th. And that's going to be at 9 a.m. And I will appoint a conflict counsel. Miss Grace, we need to reach out to Miss Maureen McLeod.
Okay, Judge, will do right now.
All right, thank you. I don't know whether she's available today. I just need her to know that she has a client who's got an SAP calendar on December 28th.
Okay, Judge.
All right, Mr. Reynolds, me resetting your case to next Thursday is not going to affect or prejudice you because you already have that other felony matter holding you at the jail.
Yes, ma'am. I have a
This,
question.
this case is not holding you in jail.
Okay, so if I bond out, if I bond out before the 28th, I'm still good.
If you bond out before the 28th, then you probably need to hire an attorney, or you can reach out to the clerk's office to contact Maureen McLeod. Currently, your bond is $38,000.
Yes, ma'am.
WIDEMAN, correct?
And you have a, I think you have a $1,500 cash bond on the current case.
You said what?
You have a $38,000 $38,000 surety bond at the present time.
What did you say about $1,500?
Yeah.
The bond in your pistol case, that bond has been forfeited because you failed to appear in court before Judge Richardson.
Yes, sir.
All right. Thank you.
Next, Judge, we have, going back to Thornton 31.
That's Mr. Finling's client. Mr. Finling, can you refresh my memory what we're doing with Derek Thornton?
Yes, Judge. I'll just flip through it really quick. This is just gonna be an arraignment from.
All right. Derek Thornton's case is 23 CR 7783J, charged with simple battery family violence from June 21st, 2022 in Fulton County, Georgia. Mr. Thornton, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finling. Upon your entry of a not guilty plea to the misdemeanor offense of simple battery family violence, your case will be scheduled for trial. At the time of the trial, the prosecution would have to prove the charge against you beyond a reasonable doubt. If the prosecution prevails and you are convicted of said offense, you could face a penalty of up to a year in prison and or up to $1,000 fine for this convicted offense. Given this information, how do you plead?
Not guilty.
Your case has been arraigned and you will get a notice for your next trial date. Thank you.
Yes, ma'am. Thank you.
Thank you, Judge.
Number 9, Mr. Brewer.
Hey, sir.
Brewer, have a seat in the green chair. Sit in the second row.
Larry Brewer is 23 CR 4510G, accused of simple battery and criminal trespass from July 19th, 2023. Mr. Brewer, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. For purposes of this plea, may I please place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am, yes, ma'am. Good morning.
Good morning, and thank you, sir. You may place your mask back on. All right, Mr. Pierre Thomas, what's the state's recommendation?
The state's recommendation is, one moment, while I pull it up on the calendar. The state's recommendation is that the defendant serve 12 months on probation, serve 4 days in custody credit for the 2 days that he's already served in custody. It looks like he was booked in on 7/19/2023 and was released on 7/20/2023. For the balance to be probated, for him to complete 6 weeks anger management, for him to stay away from all MARTA stations, and to have no further contact with Stevie Rogers. That is for count 1, simple battery. For count 2, the recommendation from the state is for the defendant to serve 12 months on probation. That has to be concurrent with count 1. And if we could sound from Mr. Rogers, as our office has not been able to get in contact with him in accordance with Marcy's law, that'd be greatly appreciated, Your Honor. But nothing further to add from the state.
It's Ms. Rogers.
Ms. Rogers.
Glad you said that, Mr. McLean. I thought I was going to think it was a Marvel character. Okay, Stevie Rogers. All right. Mr. McLean, does your client stipulate to the factual basis, venue, and ID?
He does, Your Honor.
All right. Mr. Brewer, have you consumed any medicine or alcohol recently?
Ma'am, no, ma'am.
All right. And have you understood what's going on so far?
Ma'am, yes, ma'am.
All right, you don't have to put your mask in, just speak right through it. I'll hear you, okay?
Yeah, ma'am.
Are you satisfied with your attorney?
Ma'am, yes, ma'am.
And is anyone forcing you to enter a guilty plea today?
No, ma'am.
If you decide to plead guilty to these charges, you would have to be placed on probation. You will also not get a chance to go back to court and have a trial in front of a judge or a jury. You will not have an attorney to assist you to confront your accuser, challenge the evidence brought against you, and have the prosecution try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Ma'am, yes, ma'am.
How do you plead to 1 count of criminal trespass and simple battery? Guilty, ma'am. Your sentence on simple battery is 12 months. You serve 4 days, credit for time served 2 days. If you have no other holds, you will be released within 24 hours. You must report to probation next Thursday before 3 p.m. Do you understand, sir?
Listen to the court. Listen to what she's telling you.
Again,
So she's been appropriate.
you will be released within 24 hours, but you must report to the probation office next Thursday, December 28th, before 3 p.m. The probation office is located at 132 Mitchell Street. While you're on probation, you must enroll and complete 6 anger management classes. The classes must begin within 60 days from today. Do you understand?
Ma'am, yes, ma'am.
You cannot go back to any model property. You cannot use the trains, you cannot use the buses, and you cannot be on any of their stations. Do you understand?
Ma'am, yes, ma'am.
And you should have no contact with Stevie Rogers. You have to stay 200 yards away from this person and not communicate with her in any way, form, or manner. With regards to the criminal trespass, it is 12 months probation, concurrent with count 1. Thank you.
Thank you, ma'am. You have a blessed holiday.
You too.
Can we go back to, Mr. Snelling's probation?
Before 3 p.m.
Mr. Snelling, yes. Thank you. Thank you for getting on 4 South. Officer Allison, Mr. McLean.
Thank you. You have a blessed holiday. You too.
Mr. McLean, your client, Antonio Snelling, is back on screen at 4 South. And I believe the last time we left off was probation is seeking to revoke the remainder of his 46 days, give him credit for 17 days. So he has about 13 to 14 days left to serve in the jail.
Right, Your Honor, and he was simply asking the court to consider an earlier release than that, just because it's the holiday season, just asking for mercy from the court. And he realizes there's not enough time to really do those classes now and regrets that.
Okay. Yes, Mr. Snelling, did you want to say something? I got to remind you that your attorney has argued for you, and anything you say can and will be used against you.
Yes, ma'am. I know, ma'am. I wanted to say something, please.
It's up to you.
Yes, ma'am. Yes, ma'am. I've been locked up since September 11th of this year. Since September 11th, Your Honor. I just lost my daughter till, she's dead and everything. I've been here since September 11th. I never got a paperwork when they put me on probation for this case here. I never received anything from the probation officers. I don't know how I got revoked because I never received anything from the probation. I never signed no papers. When they first gave me 45 days credit for time served, they told me to take 3 classes and put me in a year, then they'll terminate my probation. And when I got out, when they released me, they never gave me no paper. I thought they were gonna send it to my house. They never sent anything to my house, ma'am. So then a year later, they came and had a warrant on me. I never received no paperwork. I never signed no paper. I never know who my probation officer was. I even called 2 misdemeanors after 2 weeks after I got out. I called 2 probation officers. You can ask my mom. I called 2 probation officers. They have never had me in a computer. They said I wasn't even in a computer. So I tried, Your Honor. They didn't. I ain't know my probation officer name. This is my first time seeing her. I ain't never met her before. She never sent that to my house. I never reached out to me. This is my first time seeing
All right,
her.
Mr. Snelling, you're repeating yourself now.
Yes, ma'am. I'm sorry, ma'am.
You took a plea on August 22nd, 2023.
Yes, ma'am, I did.
In which you agreed to go on probation.
Yes, ma'am.
And you were required to report to probation at 132 Mitchell Street.
And nobody never gave me no address. I never had no name. They never gave me no paper.
Then it's your responsibility to contact the public defender's office to find out where to go.
I didn't even know who my probation defender was, ma'am.
All right, let me check one thing. Miss Tyson, has Mr. Snelling been convicted of any prior offenses? Or is this his first offense? First conviction?
That Mr. Snelling, right?
Right.
Let's see, give me one moment.
All right, who you missing, Ken? Ken? Yes, ma'am, who you missing? Gabriel, Tamara. Yeah, she has a big brother.
He has it looks like he has a pending case in DeKalb, a felony case in DeKalb, and he has a total of, was it 37 cycles?
That's good. Thank
Yeah.
you. All right, Mr. Snelling, I'm afraid I'm going to accept the state's recommendation. I'm going to revoke the 46 days that's left on this time. And I'm going to give you credit for 17 days. So that means you have 14 more days to serve at the Fulton County Jail. You not only were placed on probation, the judge gave you 7 months waiver of probation fees. And if you completed the conditions, your probation would have been non-reporting. You have a significant criminal record history. This is not your first rodeo at being on probation. And I don't find it plausible or credible that you did not know you were supposed to report to probation.
No, I ain't said I did not know, ma'am. I called. They haven't gave me no paper when I got out. I didn't know who.
All you need to do is come down to the courthouse and we would have told you exactly where the probation office is. It's right next door to us.
I've been locked up since September 11th. Can I get credit for that? I've been locked up since September 11th, man. My daughter just died 3 days ago.
That's my decision, Mr. Snelling. Thank you.
So I can't get credit for September 11th. I've been locked up since September 11th.
You're given credit for 17 days.
So how long I got to do, Your Honor? My daughter just died, Your Honor. I'm trying to get out. I've been locked up since September 11th, Your Honor.
Mr. Snelling, that's my decision. Thank you.
I'm saying when I get out, know what I'm saying? When I get out, Your Honor.
It'll be 14 days, apparently, 14 days.
In 2 weeks,
If
you'll
there's-
be out on January 4th.
If there is a DeKalb hold, they might pick you up right around then.
No, probation revoked. Thank you.
Your Honor, that concludes my probation matters. Can I be excused?
Yes, Ms. Allison, thank you very much. Look forward to the documents.
Yes. Can I just make an announcement also? Can the PDs make sure that they send me the petitions in a timely manner? I am leaving the office today at 4 and I won't be returning until after the holidays.
Right. We've got our petitions with us so we can sign them and send them to you.
Yes, ma'am.
Okay, thank you. Have a good day.
Have a good one
as well.
All right, for South. Oh, who do you want me to address?
No, I just got a quick announcement before you do for South. Just let me know, Judge Law, when you're ready to do the compensate, okay?
Okay, I wanted to address all these cases at 4 South and your courtroom right now, so.
Okay.
4 South, who do we have?
This is Mr. Boulay, add-on number 1.
All right, let's see. Now, I do need that breakout with Mr. Belay. Let me see if my,
All right, Miss Gray, no, hang on, Mr. McLean,
Mrs. Bird?
yes, Your Honor.
No.
Mrs. Bird?
Let's see.
I was just going to put courtroom 2 and 4 South into the breakout. Deputy Francois?
Yes.
I'm going to put your screen in the breakout.
Okay, not a problem.
So you want courtroom 2 and who else, Judge?
South, and 4 South.
Courtroom 2 and 4 South. Okay.
Yeah. 4 South, you're going to see a message on your screen to join a breakout. Mr. McLean, you're going to be on a breakout. Okay. Antavius Roach, are you here for a particular case?
Yes, ma'am.
Is this a bench warrant matter?
Yes, ma'am. I had an FTA because
And who is your attorney?
it was Mr. McLean. That's who
All
called
right.
me yesterday.
All right, we are running quite a bit behind, so we're going to hold off on that. And is there a Michael Miller also present? Michael Miller? Michael Miller? Mr. Miller, if you please unmute.
I have a question, Judge. So, Mr. McLean is in the breakout room right now?
Yeah.
Okay, thank you.
Mr. Michael Miller?
Yes,
All right, sir.
yes, I'm here.
Yes, sir. Who is your attorney?
I don't know. He called me yesterday. I don't know his name. I hadn't talked with him. We hadn't even talked.
Well, it'll be important to know who's your attorney because you've got a bench warrant.
Bench warrant? How did I get a bench warrant?
You've got a bench warrant for failure to appear in court on November 27, 2023 before Judge Richardson. So
did not.
that's
Okay,
why the
excuse me.
attorney called you yesterday so you can discuss it.
Yeah, I talked to him yesterday for a little bit, but the thing is, I didn't get nothing in the mail to come
What's
to
the
court or nothing.
attorney's
I didn't
name?
get anything.
What's the attorney's name?
No, I don't know his name. He talked to me. He said he'll see me on the Zoom. He
Okay.
said, I talked to you on the Zoom.
Then
I see you on the
please
Zoom.
exercise your right to remain silent. And I'm going to let the attorney speak for you.
Okay.
Ms. Grace, we can go ahead and mute Mr. Miller for now. Who is doing the 11 o'clock competency calendar with me?
Ms. Falk, will be back with you. If you're asking from the state, she'll be handling
Ms.
the
Falk?
11 o'clock.
Okay.
Yes.
Excuse
And
me,
as soon as
Judge.
we're ready, I'll have her come on. I'll text her to come on. Are you ready for her now?
Not really, because they're going to come back hopefully from the breakouts very fast. Yes, Mr. Roach, what was your question? Here we go.
Not to be talking out of turn, but that's exactly what happened. Well, that was my situation yesterday. Mr. McLean called me. He gave me a brief breakdown, but he ain't tell me too much. He just told me that he'll see me today.
Okay, so as soon as he comes back on, he can tell me what's going on with your case. Anything
Yes,
you
ma'am.
say or Mr. Miller say, your
Can be used
statements
against
can and will be used against you. This is a recorded and live stream proceeding.
Yes, ma'am.
So please mute until Mr. McLean gets a chance to talk to you. All right, Miss Grace, please let Mr. McLean know that we're ready to address his case.
Okay, Judge.
This was a reset from Tuesday, so there shouldn't be too much discussions now. All right. Mr. McLean, is he back out of the breakout? All right, there we are. Mr. McLean, please unmute.
There we go.
Yes, sir. And your announcement for Mr. Boulay?
Mr. Belay wishes to take the negotiated offer of the state. I've explained to him the number of extra days involved and the other obligations. He has heard those before, so it was not difficult for him to affirm to me that he understood the requirements.
Marcavius DeJean Boulay is 23 CR 7736Y, accused of battery from December 5th, 2023. This, Mr. Boulay has been, just to reiterate, you've been advised of your right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. McLean is your counsel. Mr. Boulay, since you are entering a guilty plea in this negotiated plea hearing, may I place you under oath? Mr. Boulay, may I place you under oath? Raise your right hand. Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Pierre Thomas, what is the plea offer for Mr. Boulay?
Your Honor, the offer from the state in this case is for Mr. Boulay, the defendant, to serve 12 months probation, to serve 180 days in custody, credit for the 17 days that he's already served in custody. It appears that he was booked in on December 5th, 2023, for him to stay away from the location of 2420 Piedmont Road, Northeast Atlanta, Georgia 30324, which appears to be a MARTA. For him to complete 40 hours of community service and to have no further contact with Anthony Rose, and to complete 12 weeks of anger management. And if you one moment, Your Honor, I want to see what the status of our interaction was with Mr. Rose. But if we could sound for him in accordance with Marcy's law, that'd be greatly appreciated in the interim.
Anthony Rose. Anthony Rose. I don't see any particular person with that name on screen. Mr. McLean, does your client stipulate to the factual basis, venue, and ID, and does he accept these terms?
Yes, Your Honor, he does. So stipulate and he does accept them.
All right. Mr. Boulay, have you consumed any medication or alcohol?
No.
Repeat?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you, is anyone forcing you to enter a guilty plea today?
No, ma'am.
Are you doing so freely, willingly, and knowingly?
Yes, ma'am.
Are you satisfied with the legal services you've received?
Yes, ma'am.
And has it been explained to you by your attorney that entering a guilty plea means giving up your constitutional right to a trial, to be able to confront your accuser, challenge the evidence brought against you, present any defenses or mitigating factors if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery from December 5th, 2023?
Guilty.
Your sentence is going to be 12 months to serve 180 days, credit for time served 17 days. You will have additional time to serve at the Fulton County Jail, after which the balance will be on probation. You will report to probation at the first available business day at the probation office of 132 Mitchell Street in downtown Atlanta. While on probation, you're to complete 40 hours of voluntary community service at any nonprofit agency that is not a church and not a school. You're also to complete 12 weeks of anger management classes, and you must enroll in those classes within 60 days of being on probation. At all times, you're to stay away from 2420 Piedmont Road in Atlanta, Georgia, which is a MARTA station, and have no contact with Anthony Rose. That concludes your plea. Thank you. All right, courtroom 2, do we have any other cases? Mr. McLean, we have the 2 bench warrant matters. We have a Antavius Roach and a Michael Miller. They stated that someone called them to speak with them about the case. Was that with you?
That was me. I called from the jail yesterday and spoke with both gentlemen.
All right. Which case would you like to begin with?
Either one, Your Honor.
Okay, let's begin with position number 1, which is State versus Michael Miller, 22 CR 002111F. Mr. Michael Miller's, in Mr. Michael's case, he is appearing on Zoom. He was accused of battery, family violence, and obstruction of a law enforcement officer. The case was accused on April 8th, 2022. He received a $3,000 good bond on September 19th, 2022. He had an appearance on November 27th, 2023, in which he failed to appear, and a bench warrant in his bond was forfeited. He requested a hearing to set aside the bench warrant. And here we are. Mr. McLean, why should I set aside the bench warrant?
Your Honor, I explained to him on the phone, when I was actually borrowing the front lobby's phone, that his task today would be to tell Your Honor how and why he missed court. I believe his situation was he did not receive notice. And the address shown, he tells me, and again, this was from the lobby, and we nonetheless did have a conversation. He tells me his address is 954 Washington Street in a certain apartment and correct zip code. And I could not fathom if the address was correct and if the mail was delivered correctly, then it should have gotten to him. But mail service is not perfect. And I advise people to rely more upon going to the clerk's office every couple of weeks than to let their rely upon the delivery of mail, because we all miss mail sometimes, even if our mail delivery is wonderful.
All right. You said you wanted Mr. Miller to allocute?
Yes, Mr. Miller, is there anything you can add to what I just said about you missed your mail?
He needs to have the, okay. Mr. Miller, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. What is your current mailing address?
954 Washington Street, apartment 1.
And
well, that's what we have.
It has been for many years.
I didn't get anything in the mail. I didn't get anything. Then the my bondsman, the bondsman place that I'm at now, the lady said she didn't get anything either for me to come to court.
They don't get a bond notice, just you.
Okay, well, I didn't get anything. I would have came, but my freedom depends on it, so I want to miss that like I'm here now.
Okay. Mr. Pierre Thomas, do you have any objection to the set aside and a new court date for him to appear?
This is a rare situation. I will defer to the court. I do not see any indication that he has a history of FTAs, and he does have substantially old history. So this is a situation where I would defer to the court.
Okay. I'm going to set aside the bench warrant. Mr. Miller, you need to either check your mail system or find an alternative way of checking on your court dates. Because if you don't receive your mail or there's some issue with delivery, you could end up with another warrant. And a second time around won't look so good.
I know.
So you better make sure you have an alternative way of catching up with your, keeping up with your court dates.
Okay.
Washington
I'll
Street
check
is not
into
too far from the courthouse. You can always stop by and check with the clerk's office.
Yep. But
You're the one with the open case. Did you see all these other cases with people sitting in jail with handcuffs?
yes, I did.
Okay, do you want to end up like that?
No, I don't.
Then you take the extra effort to make sure that you keep up with your court dates if you have a problem with the mail at your place. Do you understand, sir?
You understand?
All right, thank you. You're free to go. Mr. McLean, would you be able to, you know what, I'll do that. I'll do that order.
We do have a form, but I'll do that at the office if Your Honor.
Okay.
Your Honor beats me to it, that's fine.
Thank you. You're free to go, Mr. Miller. Make sure you keep up with your court dates. All right, and
Thank you.
Tavius Roach is position number 2. Miss Grace, yeah, I'm so sorry. Let me get to that. It's 22 CR 007401E. And Tavius Roach is accused of battery, family violence, and 3 counts of cruelty in the 3rd degree. In this particular case, the accusation was filed on October 28th, 2022. He was given a bond of $4,500 surety. The case was set for arraignment before Judge Morrison on September 22nd, 2023. And it appears that he did not appear, so his bond was forfeited. Hence, he's seeking a set aside. Mr. Roach, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr.
Yes.
McLean, any updates?
Your Honor, there again, I did speak to him on the phone and asked him how on earth did he miss his mail? Now, I understand that Will Rogers is now his address, whereas at the time of the incident alleged, the address was Woodward 30312. But now it's Will Rogers 30316. Mr. Roach, when did that change of address take place?
The change of address took place once I realized that I had a warrant, that I hadn't received my mail. So my auntie is a captain down there, so she helped me change my address because the address that I had at first was some apartments, and I didn't necessarily get it which way. I'm not gonna say like why was the reason why I didn't get it, but I didn't receive my mail. So.
This is the time to say that, Mr.
Okay, well I didn't. Okay, well the apartments, because I don't have my own place, so I was getting the mail to my cousin's house. So the mail, he didn't get the mail. The mail didn't come, so I changed my address to my grandmother's house, and
Mr.
she
Roach,
has.
do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
So you do not have a mailing address, put your hand down, prior to you getting a warrant. Is that correct?
Yes, ma'am. But I mean, I have an ID, so like my ID didn't even have my mailing address on it. It had my old apartment that I lived at like 3 years ago.
So how do you receive notices? How is the court supposed to notify you?
I had gave them my cousin's address where I was living at right
And
then.
how often do you check on that post?
Right then, I was living there every day, and we never received anything. So to cover my own self, I asked my grandmother, who has a house, they got her own mailbox because this apartment is like a big thing in mailbox. So to make sure I cover my end, I asked my grandmother because I still don't have. That's where I'm at right now. She has a house. I asked her, can I get my address changed there? And she said, of course. And I'm gonna make sure I'm on top of it. And on top of that, I'm going to be calling down there now. But this is my first time actually going through this, so I never really been in trouble, so I don't really know exactly how I go. And that's still not an excuse, but it's still just new to me. So I apologize.
Your Honor,
Mr. McLean.
We got an odyssey and did the thing where you can hover the cursor over the addresses. And indeed, he is correct. He changed his address officially with the clerk 8 days ago after realizing that he had missed out.
Ms. Pope, what's your position?
Yeah, the state doesn't oppose setting aside the bench warrant. He does only have one prior arrest before this, and it was for driving while license suspended in 2015. And that, so
this bench warrant is set aside, and just like the prior case, Mr. Roach, this is an open, active case against you, and you are responsible for making sure we have your correct dates and that you keep up with your notices. So if you're counting on somebody else to receive your mail, you got to take the extra step to make sure you go check on your mail.
Yes, ma'am.
If you don't rely on that, you need to swing by the courthouse ever so often.
I see
and
the
come to the clerk's office.
I honestly see the significance of it at first. I see the significance of it now because I've never been through this.
Because right now you are arguing your case from the comfort of your home. If things didn't go right, you'll be arguing from the comfort of the Fulton County Jail while in handcuffs.
Yes,
So
ma'am.
you decide which option you would like.
I like it better.
I thought so. All right, thank you. Don't forget to always keep up with your mail. Thank you.
So I have one question. Please, I have one question.
Quick.
So I expect a court date at the Will Rogers now. So y'all don't tell me one now.
Yes.
I'm sorry, Mr. McLean, go ahead and answer that question.
Right, I was gonna say, yes, they will send the mail to you at what I'm looking at on the paper here, the full Will Rogers address.
Yeah, 3065 Will Rogers Place.
However, if I were you,
I'm still gonna call.
If every 2 weeks you show up in person at the clerk's office on the first floor which oddly enough is one floor above the ground floor of 160 prior, then you will not miss your court date regardless of how good the mail is.
Yes, sir.
Okay.
Thank you.
Thank you. No problem. Thank you so much.
All right, you're free to go. Probation status of the cases, probation revocation add-on. Antonio Snelling, his probation was revoked and to serve out the rest of the time. On the probation revocation main calendar, Boynton was continued on probation. Mitchell Hill was time served. Daniel Holton was continued on probation. Lamar Ridley is reset to December 28th, probation revocation calendar. Christelle Upshaw is continued on probation. And position 13, Damian Williams is continued on probation. For the all-purpose add-on calendar, Mr. Position 1, Goulet is the plea. 2, Reynolds is reset to December 28th, 2023. Maureen McLeod is appointed conflict counsel for Mr. Reynolds and needs to be notified of his new court date. Position 3, Amir Thomas, and 4 were pleas. 5 and 6 were null clause. Yep, okay. Main SAP calendar, position 1, Barth is reset to December 28th. Position 2, Beavers was a plea. 3, a plea. 4, Mario Bibbs is reset to the competency calendar, and that would be Ms. Abdon, did you want it on December 28th?
I'm gonna just come over there.
You can announce from there.
Okay, we're just gonna try to reset it to, for bids 4 weeks out, and we can discuss it on the calendar.
Okay, how many weeks out?
4, please.
It'll be January 18th, 2024 at 11 a.m.
Thank you.
Position 8, Roy Brammer is, I think I've got a fugitive hold on position 8 and it's reset to 12/28. Position 9, Larry Brewer. Any announcements, Casey?
That was a plea.
All right.
That was the position of 8, you said
12/28. He's got a fugitive hold.
Number 9 was,
Yeah, 9 is a plea, 10 is a plea, 11 is arraigned and further notice for trial. Position 12, Kane is a plea, 13 is arraigned and further notice for trial or transfer. 14 and 15, Antonio Cloud were pleas. 16, Coerde is a plea. No, that's reset to be heard at the 11 a.m. calendar, sorry. 17, Dorsey is arraigned and further notice for trial or possible transfer. 18, Floyd is a plea. 19, 20, and 21 were pleas. 22, Garrison is a plea. 23 is a arraigned and further notice for trial. That's Sanchez Griffin, along with the other case ending in 7768F. 24, Kevin Harvey is arraigned and further notice for trial or possible transfer. 25, Jones is a plea. 26, Quinetta is a plea. 27, Paul Riley is arraigned and further notice for trial. 28, and Larry Sims is a plea. 29 is null pros. 30, Christopher Smith is loaned out to Grady, so I'm going to reset this to December 28th. 31, Thornton is arraigned and further notice for trial. 32, Philip Ware is Mr. All right, he was released on December 19th, so that's further notice for trial. 33, Wilson was a plea. 34, Wook was a plea. Any corrections? Okay. All right, anyone who is not involved in the competency 11 a.m. calendar, you're free to go. Anyone who wants to be part of the competency breakout session, please start your video.
All right, thank you. Thank you, Judge.
All right, you're welcome. Take care, Mr. Finley.
I'm gonna sign every petition I've got.
Thank you, Judge.
Thank you, sir.
I printed out all. I don't want it signed.
So courtroom 2, Mr. McLean, are you going to be in the competency calendar?
Well, there is that client that I met.
Oh, that's right.
yesterday.
Okay. Okay.
Mike, I can do that for you. He has told me what happened. Mike, what you end up getting?
All right, Miss Grace, if you could put, you can stop the recording in the live stream since we're going into a breakout.